People of the state of Michigan versus Daquan Nitz 24-03600. Please.
Good morning, Your Honor. Middle for the people.
Good morning, Your Honor. Jacob Sargent Support, Assistant Public Defender here on behalf of Mr. Mitz. Mr. Mitz is present at council table. He's standing to my right.
Okay, Mr. Nitz is scheduled today for a preliminary examination on assault with intention to great bodily harm less than murder, domestic violence, and malicious destruction of property less than 200. How are we proceeding on this?
Your Honor, and necessary witnesses not present this morning, and therefore the people are unable to proceed with the preliminary exam. Due to that circumstance, I expect a constant motion.
Thank you, Your Honor. At this time, the defense moves to dismiss this matter. The defense is prepared, able to proceed today. Mr. Mitz understands that if Your Honor grants this request, it would be a dismissal without prejudice. He has also been advised and cautioned about PA 53, how it might take some additional time before that order, if the case is dismissed, clear as lien. Mr. Mitz understands that. At this time, though, respectfully, the best moves to dismiss, Your Honor. Thank you.
I'm sorry, you said something about a PA 53?
The no contact order sometimes takes 48 hours to clear lien, Your Honor. And
okay, I thought you were it was scheduled for a PA 53. Got it. Okay.
my apologies, Your Honor.
No worries. The motion to dismiss is granted without prejudice. We'll get you a copy in just a moment. Okay, sir?
Thank you, Your Honor.
You're welcome.
Yes, We're
ready to go whenever, but
I've done that before though.
I don't know how, I don't like this.
Oh,
I hate
so
that.
please, I'm
Is
sorry.
that the new one or the old one?
I don't know, but someone needs to show me how to get back to this. This is the one. Let me see. I volunteered to do a mock trial. Um, And who was going to be a plea?
That's gonna be Salzman, Your Honor.
On the record in the matter, the people of the state of Michigan versus Matthew Luke Wolf, 4-01673.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Jacob Starks, fourth assistant public defender, here on behalf of Mr. Wolf. Mr. Wolf is present at council table. He's saying.
Okay, Mr. Wolf, you were scheduled today to have a preliminary examination on a count of controlled substance. My understanding is that you now wish to retain private counsel.
Yes, ma'am, I'm working on that as we speak.
Have you already identified counsel or
I have an appointment with Brandon, on the 26th.
whom?
Brendan Besiga, Your Honor.
Oh.
Yeah, he's one, but I'm also looking at another one right now that told me that they'll talk to me sooner because of the litigation purposes right now. So with that being said, and for the court, I would like to gain new counsel that is willing to, benefit my purposes, please.
Okay. You have the right to retain counsel, and I just need to advise you that you have the right to have your preliminary examination within 21 days of the date that you were arraigned. So that's why it was scheduled for today. In order for me to reset this, I need to know if you're going to waive the 21-day timeline so this can be reset for you to get counsel.
I don't have proper counsel to litigate that to me.
Litigate what?
Well, as far as saying if that's the proper thing to do.
Is your counsel here today? I'm asking you to agree to extend the timeline because you're requesting an extension of the timeline.
Yes, I would
Okay.
agree.
Thank you. No one's
welcome.
threatening you to do that?
No,
Okay. I'll have the matter reset. That way you can get an attorney and they'll file a substitution of counsel versus an appearance. That way Mr. Sartz can come off the case and then discovery can be provided to the new attorney, okay? The date I'm going to give you will be the date it's set for a new exam. If that date doesn't work for the attorney, they'll let me know once they get a substitution, okay?
yes, ma'am.
April 3rd at 9:30. April 3rd at 9:30.
Deferred at 9:30.
Get your notice to appear. Do you have any questions for the court?
No, Your Honor, thank you very much.
No problem. Any additional matters for the record?
I'm sorry, Your Honor. I think the court said it, but I missed it. Is that going to be a PCC or is that the next
It's
exam
gonna
date?
be an exam date.
Okay, thank you, Your Honor.
Thank you.
No problem.
If you want the actual papers off.
Record in the matter of the people of the state of Michigan versus Jeanette Horton, 25-00337.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Jacob Starks, fourth assistant public defender, here on behalf of Ms. Horton.
Okay, Ms. Horton, how are you today?
I'm better today, thank you.
Very good. Okay, you were supposed to be having an examination today on count 1, home invasion, first degree. And I don't know that we're proceeding today. What's going on?
Your Honor, a necessary witness for the felony is not present. However, I had a witness from the building in this case, which is the subject of the malicious destruction of property. He was present. Since we're unable to move forward on the felony charge, the people would be seeking to amend the complaints to move forward with the malicious destruction of property charge. We'd ask that this be set on the district court calendar for a pretrial.
What was the subject? It says the same victim in my complaint.
Well, the malicious destruction of property was the apartment for the victim, but it was the building manager was a witness to the altercation, and the building itself is seeking restitution for the damage.
Okay, so the damage is alleged to be the building. Got it. Okay. It says this charge is malicious destruction of personal property.
think that's because the way the police report reads, it's the apartment. We can amend that to malicious destruction of the building. Same value.
Okay, sounds good. So the felony matter is unable to proceed. You're making a motion to dismiss.
Yes, Your Honor. Defense counsel moved to dismiss the felony charges at this time. Respectfully, the defense is prepared and able to proceed. Ms. Horton is present, and Ms. Horton is not waiving her timeline or anything like that. She wants to proceed today. If people are unable to proceed at this time, Your Honor, defense requested dismissal of the felony charge. Certainly, the prosecutor has the freedom to go and amend and pursue misdemeanor charges. The prosecutor's office wishes to do so. Your Honor, just may I also be heard on bond.
The felony will be dismissed without prejudice. We'll get you a copy of the dismissal in just a moment. Yes.
May I ask just a procedural question, defer to the court on how it wants to proceed? Because it's the people's motion to amend the complaint to a misdemeanor. Should it be a nollie of the felony counts, or does it matter to the court?
You're just continuing on count 2?
That's correct, Your Honor. Yeah.
No, you don't need to nollie.
Okay,
Just
thanks.
Put it on the pre-trial document.
Sounds good. Thank you, Your Honor.
I'm gonna give you a pre-trial date today. March 24th at 10:30. March 24th at 10:30 for pre-trial.
That's what you said. I'm just trying to.
And you want to place our spot.
Thank you, Your Honor. Yes, in light of the felony charge of being dismissed this morning, Your Honor, Ms. Horton is currently charged with 2 misdemeanor counts. Respectfully, I request reduction in her current bond amount down to a personal recognizance bond. Ms. Horton is indigent. She's unable to pay a cash surety bond at this time. Respectfully, if she is granted a personal recognizance bond, she's not a flight risk at all. She has deep roots in the community. She has a lot of local family members who can keep track of her location. She will make sure she complies with all the court's orders. She'll make sure that she shows up with all the court dates. She takes care of her grandchildren. She provides very necessary role in her grandchildren's lives. She provides them with care, love, and support. It's also very important for her family because her daughter needs to work and her daughter relies on support to provide child care for her grandchildren. Ms. Horton is also an entrepreneur. She wants to get back and start working again. Before she was in custody, Your Honor, at one point she owned her own cleaning company and she's owned businesses in the past. She'd like the opportunity to pursue those opportunities. She's very active in her church community. She'd like the opportunity to get out and go and reconnect with members of her church. She goes to mass, or she goes to church, excuse me, very, very frequently. And respectfully, with these charges being reduced down to a couple misdemeanor counts, I request a personal recognizance bond on behalf of this court. Thank you.
People will defer to the court on that, Your Honor.
Ms. Horton. I'm familiar with Ms. Horton. I don't know if she shared that with you. She did actually at one point attend the church that I
got a closing rest.
did I ask you to talk over me?
No, ma'am.
I said she did at one point attend a church that I attended. And that's reflective on the record from a previous matter where you told me you went to the church that I went to. I recognize that you now have to share with the court that you go to Pilgrim Rest because you came here about a month ago to ask me to amend a payment plan and you shared that with me. So I'm very familiar that you're now engaged at Pilgrim Rest. That's not the point that I'm making. The point that I'm making is that the purpose of you aligning yourself with the church is not for you to throw it out at court. It's for you to make a change in your life. And if the court issues a bond and or probation requirements, you don't get to pick and choose which ones you're going to follow and which ones you're not going to follow. And that's been a history, not just in this court, but a history for you in other courts, where you pick and choose which one of the rules you're going to follow. And so I'm going to amend your bond. I'm going to tell you what the requirements are, and you're going to follow all of those requirements. Otherwise, your bond will be revoked, okay? You are going to get a $500 personal recognizance bond with GPS tether and scram tether. which was ordered originally in this matter anyways, because scram tether is essential because that's one of the issues. You understand? Okay. While we're in a scram tether, it was previously ordered for you to do random ETC testing. I'm not gonna order you to do that if you're wearing a scram tether. I think that's excessive. You're not to be within 2,000 feet of the exclusion zones, which is the area where Miss Sams lives, works, goes to school in the area of the alleged incident, 3610 West Miller, apartment B, okay? Now, do you have personal belongings there of some sort?
I do.
Okay, you need to make arrangements for someone else to get them, okay?
Yes, ma'am.
Okay, and then your attorney needs to communicate with the prosecutor about who's gonna get it and what time so that it can be done, okay?
Yes, ma'am.
You're not allowed to go.
I
You
do.
understand that?
Yes, ma'am.
Do you have any questions about your bond condition?
No, but I'd like to address my payment plan you helped me get on for my $5. I missed it because I'm in jail. So
It's not before me today,
I won't have
so
a warrant, will I?
I've not issued a warrant for
Thank
you
you.
for that. Just get back on the payment.
I
plan.
will.
Okay,
Yes, ma'am.
okay. Any other questions?
No, Your Honor. Thank you.
Thank
No,
you. God
You're
bless
welcome.
you.
Stacey, you look better because you haven't been putting,
No drink,
alcohol
no
in your
wine.
body,
It's
exactly.
wine. Jesus turned water into wine.
that's not what you said last time.
I know, it's wine.
Right,
I'm
and it's
done.
cold outside, and
It's cold.
I know what you like to do when it's cold.
Drink, but I'm gonna not drink.
Thank you.
I'm gonna drink the living water.
That's now,
and my coffee.
now you're talking.
Hallelujah.
Thank you.
I'm going home.
Thank you, Your
Yeah,
Honor.
Hallelujah.
unless somebody else is holding you.
Thank you, Jesus. Hallelujah.
The guy, he's in our room. He's supposed to be in front of Judge Ward. Mr.
I
Granberry.
chatted him, but I don't know.
They ain't working. Let's see. What happened here?
It went bad.
Oh, I might have been in the wrong thing. I gotta do it for, I was in the same. Oh, I'll do it for that. Mr. Granberry,
Yes, this is him.
You're in the wrong courtroom. You're supposed to be in Judge Ward.
Judge
Do you
Ward.
need her ID?
I can get it from offline. What's going on is I'm late and I'm trying to let everybody know I'm on my way.
We'll message them and let them know that you logged into my courtroom by accident.
Okay, thank you.
You're welcome. Just a piece of here.
Yes, ma'am, I do.
Okay, on the record, in the matter of the people of the state of Michigan versus Brett Salzman, 24-02833.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Brett Saltzman standing to my right this morning.
Okay, today was the date scheduled for preliminary examination, but there's going to be a plea. Do you have a plea sheet?
I turned that into the one that's right there. I may have posted to hand you, Steve.
Thank you, and the vice rights.
That's all there.
Thank you.
Yes, ma'am.
Okay, so I have here that the offer is for the defendant to plead guilty to trespass under MCL 750.552. Is that accurate?
Yes, it is, Your Honor.
There's a sentencing agreement of no upfront jail. We don't usually give people upfront jail for trespass anyway, so.
That's accurate, Your Honor, and we requested no upfront, or we agreed to no upfront jail for a very specific reason.
Did you want to put the reason on that?
Oh, yes, Your- well, we're going to be requesting a term of probation. The court hasn't asked, but the people would object to any immediate sentencing. The victim in this matter is the defendant's mother. The victim is present. We are requesting an assessment on the defendant prior to sentencing and a sentencing date once an assessment has been done in order so that we can address concerns about sentencing.
So in fact, the killer brew is a term of probation.
Correct.
That would probably be a more accurate description. Yes, Your Honor.
Okay, sounds good. And that's how you want to proceed, sir?
That's okay. I believe I've had an assessment. I go to MMRS outpatient. I'm also involved in CMH's outpatient. I think it's called LTRS. I'm getting started on that one.
Okay.
But I can do another assessment.
Well, I asked you if that's how you want to proceed. And when I ask that, I mean, do you want to accept the plea, understanding that it comes with an agreement that you will be placed on a term of probation, if that's what the court agrees to. And that as part of that, that you'll have to undergo a substance abuse assessment. If you've recently undergone one, you don't need to do a new one.
Yeah, yes, I agree.
That will just need to be forwarded to probation. So you understand that?
Yes,
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
yes, Your Honor.
Okay, and so, sir, I have an advice of rights and plea information sheet. It's 2 pages. Is that your signature?
Yes, Your Honor.
Okay, you've read or gone over these rights with your attorney?
Yes, Your
Do you
Honor.
understand all the rights listed here?
Yes.
Do you have any questions about these rights?
No, Your Honor.
And you're willing to give up each of these rights today to plead guilty to the amended charge of a trespass?
Yes, Your Honor.
Okay, is anybody threatening you to do that?
No.
Any promises being made to you to get you to give those rights up?
No, Your Honor.
And so you understand that you're going to give up your right to be presumed innocent until proven guilty, which also accompanies the right to require the prosecution prove your guilt at a jury trial by proving each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes, Your Honor.
It also comes with giving up your right to remain silent at any trial, not have silence be used against you. You have the right to subpoena witnesses to your trial that would testify on your behalf or present evidence that you believe show a defense to the charge that's being brought against you. And you have the right to waive your silence and testify on your own behalf. You understand that?
Yes, Your Honor.
Are you on probation or on parole?
No.
You understand that by entering a guilty plea, it could result in a conviction that you may need to report to a current employer, or you may need to report this conviction on a future job application.
Fortunately, yes.
Okay, and also could have impact on travel or immigration status that you may see in the future. So you may want to go on vacation out the country and it could have impact. Do you understand that?
Yes, Your Honor.
As to the amended charge of trespass, how do you plead?
Guilty.
Factual basis.
Yes, Your Honor. Mr. Saltzman, I want to turn your attention back to July 30th of 2024. Were you at 1726 Lindbergh Drive?
Yes,
That's here in Lansing,
yes,
Ingham County,
yes,
state of Michigan.
yes,
And that is your mother, Susan Saltzman's house, is that correct?
yes,
And you were originally there with permission to be there, is that correct?
yes.
And at some point in time, you were asked to leave the residence, is that correct?
Yes, I was there with a lady friend and she was not happy about that.
And she asked you to leave, is that
Yeah,
correct?
she asked to leave.
And then what happened next?
I walked her down the street and then returned.
And you returned back to the property, correct?
Yes.
How long after she'd asked you to leave?
I don't know, maybe 15, 20 minutes or so.
And at that time, she didn't give you permission to be there, is that correct?
Correct.
No, I have no additional questions from Mr. Saltzman.
The additional factual basis.
Just one question, when you returned to that residence after being asked to leave previously, as you returned, you knew you were doing so without permission to return, correct?
Yes, because I was told to leave.
No further questions.
The court was satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Your matter is scheduled for sentencing April 17th at 9 o'clock in the morning. Prior to sentencing, you need to meet with our probation department. So you'll go downstairs today, 1 floor down, and check in before you leave. They'll get you all set up for your pre-sentence interview. If you've recently undergone a substance abuse assessment, like you said, you just have to sign a waiver to get that released
Okay.
through probation, okay? Do you have any questions for the court?
No, yeah.
You are able to appear for sentencing via Zoom, okay?
Yes, Your Honor.
Any additional matters for the record?
No, Your Honor.
Nothing else on behalf of Mr. Saltzman other than, Mr. Saltzman, I will be in a jury trial that morning, so another attorney of mine will be present. Is that okay with you?
Did you want us to change the date?
If he's good with having another attorney, we don't need to change it.
I guess that's okay.
We can change the date if it's.
You can change the date.
April 24th at 9.
April 24th at 9.
I hope we're finished with the trial on the 24th. It's might be a 2-week long trial.
It's likely, how long?
2 weeks homicide trial.
It's homicide trial. Okay. We can move it out earlier because he's already done an assessment to review. What day do you start your trial?
It's 14.
You can do April 11th at 9.
April 11th
Same time,
at
Judge.
9. That's correct.
We'll be there.
Any additional matters for the record?
No, Your Honor, thank you.
Oh, thank you, Your Honor.
Just have to see you wait for me.
Have a nice day.
Thank you. I would actually go to the approach.
Yes, ma'am.
Yes, please, Mr. Freeman has Brown. Is Brown here?
Yes, Judge.
Okay.
Witnesses are not.
Can someone let these people know they need a new charger? They need to get them a charger.
So does he need to go? I thought he was supposed to go there though.
Yeah, he was, but I don't know. It doesn't sound like they got the message. And the issue is that he needs a charger. Someone needs to tell me. He needs a charger. Who's the attorney?
Either Warren or Mr. Riley.
Yeah, let's hopefully it's Warren and tell her they need to call, otherwise I'm revoking this bond. Wow. I saw Miss Donnelly, but I don't see any more. Okay, all right, thank you.
I have a police officer with me, so the victim's not here. Yeah, okay.
May.
Oh, okay. All right. On the record in the matter of the people of the state of Michigan versus Cameron Brown, 24-03-688. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Mr. Brown, who stands to my right.
Today was the date that's scheduled for preliminary examination. However, this file's in warrant status. In warrant status. Tether's been cut off
Oh,
for a long time.
that's news to me, Your Honor. I didn't realize that.
Tether's still on my leg.
Have you been paying for the GPS tether?
I got Medicaid.
Is the tether on?
Yeah.
It says that your tether was cut off for non-payment in December. And pretrial services followed up. And then as of the 14th, they followed up, and it says it's been shut off due to non-payment. Show me that your tether is on. Is it activated? It doesn't look activated.
I mean, there's no light or nothing that flashes. The only time you hear anything from it is when you charge it.
The tether's not on.
That's just how it works.
No, that's not what they said.
It doesn't.
They just notified us on the 14th that they confirmed it's still off. It's been off since December.
That's what I gotta put on. Call, notified, anything. I don't have
December
payments because
23rd.
it's free service.
Let's see here.
Insurance, I got medication.
December 23rd, it says pretrial services received communication from JSG monitoring that the defendant's tether was turned off due to non-payment. Let me give you the contact for JSG. You have a seat over there. Have a seat over there. Did you hear me on?
Yes, ma'am.
I want a phone number. Did you send me the number?
Count making quickly.
This is. I was trying to reach JSG. Did I reach the right number? JSG. Okay, thank you. That's nothing. Again, quickly. That's the number you just gave me. I have that one. No, it's just Johnson and report and this report and review. I have a gentleman report when I received a memo from pretrial services. It stated that his GPS was cut off in the 23rd and then 14th. They said that pretrial services followed up with JSG. And the status of the defendant's tether was still cut off non-payment. He's in my courtroom now telling me it's not cut off. I'm just trying to confirm. His name is Cameron Brown. Correct. He said he has Medicare. He said he has Medicare, so he said he believes it's on. It's a Cameron, middle name is Dewan, Dawon. Brown is the last name. Okay, and so is this, he's here with a tether on, and he's supposed to have some lights on or something? How would he know that it's cut off? Yes. A phone, you all won't notify him? Oh, okay. Okay, sounds good, thank you. Okay, they've confirmed the device is off and that the device would have audibly told you before they shut it off that they were shutting it off.
Where is it?
What was supposed to happen on this case today?
Your Honor, the victim in this matter is not present. It also looks like from the notes, prior to my being involved with this case, it looks like it was previously set for a preliminary exam and the victim wasn't present at that hearing either. So I had expected the defense to make a motion, and if the victim wanted to get in touch with our office, so she'd be free to do so.
Okay, it's more than one victim, is that correct?
I think there were two, Your Honor, but neither.
Neither appeared, yeah, that was what my notes stated. Counsel, how do you want to proceed? Counsel,
Yes, Judge?
how do you want to proceed? You know, our thing works now.
It didn't last time.
It didn't work last time?
No. We tried.
Oh, I didn't know that. No, it's never worked. So
It did work for you a couple weeks ago. I don't know why it didn't work this last time. We'll have to get them over here again.
Judge, it appears as though we've got two separate issues going on here with respect to the preliminary examination. Counsel is correct. This is the second time that it's been scheduled. Witnesses did not appear on either time, so I would respectfully move for a dismissal without prejudice as to the offense. If the court is intending to take some action with respect to the tether, I would respectfully request a hearing.
The concern that the court has as to the bond and the tether requirement, the concern I have about that is his tether was shut off on the 23rd of December. When the previous prosecutor came here on the 2nd, they had recent communication with the victims, and they were unclear as to why the victims were not here. Now I don't know if the victims were tampered with while the GPS tether was off.
That was going to be my argument, that the purpose for the tether is, first of all, to find out where the defendant is at all times, whether he's had any contact with the folks he's not supposed to have contact with. I don't think there's any complaint of him having contact or any the other terms and conditions of his pretrial release, whether it be alcohol consumption or controlled substances or purchasing a firearm or ammunition and a whole host of various terms or conditions. I don't think that there's any evidence that he's violated. If it was a misunderstanding.
Evidence that he violated his bond?
I'm sorry?
There's no evidence that he violated his bond?
Yes.
Yeah, your chief, not having an active tether is a violation of bond. That's why he's in warrant status today, because he's required to keep the tether in working order. And then the tether company just told me that they send a notification through the tether to tell you they're turning it off. Also, he was ordered to report to pretrial services, and he's supposed to be reporting to pretrial services, and they also called him to tell him that his tether was off.
Thank you.
Your client's raising his hand.
Yes, Judge, I didn't understand.
You might want to go, I don't know if he wants to say it to you privately before he puts it on the record. You have something you want to say to your attorney? That's the concern that I have. Nonetheless, we don't have witnesses here. This is the second time they were supposed to be here. I don't even have information that you've spoken or your office has spoken to the witnesses since January 2nd. Is that accurate?
That's correct, Your Honor.
Okay. I'll grant your motion to dismiss without prejudice.
Thank you, Your Honor. Is the court intending to further its investigation of the tether?
I don't see how it's meaningful to have a hearing on whether or not his tether was paid for or not. It either was paid for or it wasn't. And it's not active now. And so having a hearing to prove that it's not active is not going to be meaningful.
Understood. Thank you.
He has to go back to Ingham County to get that removed from his leg. The people have the right to reissue this charge against you. Do you understand that, sir?
And I please impose upon the court staff to send an email to the court.
They will.
Thank you.
Sounds good.
Yeah. You too, sir.
Where does the Vince go? Is he
I
in
think
the
he's just,
courtroom?
He's just outside.
I think he's just in the
Oh,
hallway,
okay.
Your Honor. So for, it sounds like we are going to be running an exam on Perez, Your Honor. We are prepared to run the exam on Scruggs. However, I saw yesterday there's a new PA 53 violation. It sounds like he's going to be pleading not guilty to that. So with respect to the bond violation,
Is the victim here?
the victim is here. We're ready to run the exam. But if he's going to plead not guilty to that latest bond violation, I don't know if the court wants to.
The victim's here today. We can run testimony on that today. It's an allegation of a phone call.
It is. So, and she's certainly willing and prepared to testify to that, but I don't have anything else other than her testimony as far as that's concerned. Okay, that sounds good to me. All right, so it looks like those are gonna be those two exams.
Okay. We'll start with Scruggs.
Okay, yes, Your Honor. I only have the one witness. I'll go give her a heads up.
Sir, you're free to go. You gotta go back to Ingham County to get that tether removed though. There you go.
Thanks.
Sorry, scrub. We're starting, you can come out, we're starting scrubs.
She says she says she submitted it. She did turn it in. So that's what matters.
Your Honor, my client and I just step out really quickly, talk about something. Thank you.
Hang on.
You said the May 18th, is it on block for the Friday too?
May 8th and 9th, yeah.
Well, are you ready? On the record in the matter of the people of the state of Michigan versus Chase Scruggs 24-0357 FY, appearance please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Dustin Coons for Chase Scruggs, who's here to my right.
Okay, today was the date that was scheduled for preliminary examination. I do have, let's see, one bond violation that we were to address today. I have a new one. The allegations of this bond violation alleges Mr. Scruggs that on or about February 14th, 2025, at approximately 1:35, the alleged victim received a phone call from your number. This number was confirmed by her to the officer, and that the officer noted that this is also the number that was identified as yours on SR and S. The victim alleged that she did not answer the phone call. There's also allegations that in January 2025, that the victim received text messages from your mother. The victim's mother received text messages from your mother, a lengthy text message accusing the victim of ruining your life on purpose. So those would be violations of your bond conditions of no contact directly or indirectly with the victim. If you're found to be in violation of your bond on each of these allegations, you could be sentenced to contempt of court. It's 93 days in jail on each, the maximum penalty, and or $7,500 in fines each violation. You understand that? Okay. My understanding is he's entering a not guilty plea, correct? Okay. And so any other preliminary matters before we take witnesses?
No, Your Honor.
And just, I guess, so the record's clear, my understanding is the court will proceed on the hearing on the new bond violation today. Is that right?
Correct.
Okay.
Your Honor, I apologize. I guess the one thing I did want to put on the record is that the bond violation that we heard for previously with the car being cited outside, I don't think people can meet the burden on that particular one, so we're going to request that we not move forward on that. However, with respect to the new allegations, the people are prepared to move forward.
You can have a seat.
And thank you, Your Honor. And the people call Olivia Winter Shook. And before you sit down, we'll look at the judge. The judge is going to swear you in.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Okay, you can have a seat there. There's a microphone in front of you. The purpose of that microphone is so that the lady behind you can take down an accurate record of what's being stated in the court. That microphone will not elevate your voice, so you need to speak loud and clear, okay? If there's an objection from either of the parties, you will stop speaking and the court will make a ruling on that objection, and then I'll tell you if you can give us that response enough, okay? You can't say mm-hs, uh-huhs, yeah, or head nods or head shakes. You gotta use your verbal responses in order to answer the questions. Otherwise, we won't know what you're saying. First, state your first and last name and spell both.
Olivia Shook. OLIVIASHOOK.
Counsel, you can proceed.
Thank you, Your Honor. Ms. Shook, I am going to take you back to October 27th of 2024. Do you remember anything unusual happening that day?
Yes.
Do you remember your address where you stayed on that date?
6264 Cooper Road, Lansing, 4911.
And is that address in the county of Ingham? Do you know a gentleman by the name of Chase Scruggs? How do you know Mr. Scruggs?
We had a relationship and I started together.
How long was your relationship?
It was on and off for about 4 years.
Can you speak up, please?
It was on and off for about 4 years.
Thank you, ma'am. Would you recognize him if you saw him?
Yes, I did.
Do you see him in court today?
I did.
Can you point to him and identify an article of clothing?
Like, gray jacket.
Your Honor, may the record reflect that.
Any objection?
No objection for Your Honor.
Identification's noted.
So on October 27th, did you see Mr. Scruggs that day?
I did.
Can you tell the court about that interaction?
I believe that day, I had to send off at home with a friend. I had some breakfast in my house. I had walked into my bedroom. My bedroom door or my bedroom window was open. I'm sorry, and my air conditioner was sitting on the floor of my bedroom.
And was there somebody in your bedroom?
Yes, it was just.
The defendant was in your bedroom?
Yes, sir.
Okay. I think you indicated the window was open and the air conditioning was on the floor?
Yes.
So before it was on the floor, where was that air conditioner?
In the window.
The window that was open?
Yes.
Okay. That address, 6264 Cooper Road. Do you live alone there?
I do.
Has Mr. Scruggs ever shared that residence with you?
Yes, he has.
And prior to October 27th, how long had it been since he shared that residence with you?
Since he lived with me, it had been like a year and a half. But he was over just about every day. Up until probably August and September.
Okay. Does he have a key to your apartment?
No, not anymore.
Did he have a key to your apartment on that day?
No, not that I'm aware.
Did he have permission to be at your home when you were not home?
No.
How do you know? Did he, had you communicated that to him?
That he was the LLC?
Yes, ma'am.
No, I hadn't talked to him prior to that.
Was there any reason, in your opinion, is there any reason he would have had to believe he was allowed to enter your home without you present?
No, sir.
At that time, were you two in a relationship?
Not necessarily.
You said he was on again, off again, correct? So at that time, was this an on again period?
At the time, no, but prior, yeah.
How long prior to that?
Like I said, we had split up about like August. In August of this year, or I'm sorry, last year.
So it would have been more than 1 month, but almost 2 months?
Correct.
Okay. All right, so let's go back to the moment. What time of day was this?
It was nighttime. I want to say anywhere between like 8 p.m. to 9. Might have been a little bit earlier. I know it was in the evening though.
It was nighttime?
Yeah, it was in the evening. Yes.
And was it late?
Yes, it was dark out.
Okay. Um, Do you remember approximately what time you called the police? You don't remember?
No, I called them shortly after though.
If I were to show you a statement that you gave to the police that night with respect to what time this incident occurred and when you called the police, do you think that would refresh your memory?
Yes.
Is that yes? Your Honor, may I approach?
Yes.
Handing you the police report with your statement to the police from October 27th. If you could just look it over, read it to yourself, and when you're finished, if you could just look up at me and let me know. Does that refresh your memory?
Yes.
Okay, I'll take that back from you. Thank you, ma'am. So do you recall what time of night that was, ma'am?
I mean, that's a hours, I'm not sure, but that's the day of 6 to 7. What I think. I'm sorry, I don't recognize the time in there.
So if I were to describe that time in international time as reflecting midnight,
Okay.
do you have any reason to believe that would be incorrect?
No.
Okay.
I did call a little bit after, correct, yeah.
So it was after midnight on October 27th.
I did call a little bit after.
Okay. And you said you were dropped off. And did you say that you heard something in your home after you were dropped off, before you went inside?
As soon as I entered, I heard weapons coming from my bedroom. Correct?
Okay. I assume you were surprised to see Mr. Scruggs in your bedroom.
Very.
What happened then next?
I was in shock. I just stared at him and he left immediately out of my door, out of the front door.
Can you explain to the court how he left? What happened when you saw him and he tried to leave the home?
We didn't say anything. We just walked right past him and walked out of the door.
Did he make any kind of contact with you as he walked past you?
No.
You don't remember him touching you?
No.
When with respect to the air condition that was on the floor, was it in that condition before you had left your house earlier that day?
No, sir, absolutely not.
Okay. Were you able to just determine how the air conditioning unit might have ended up on your floor?
I believe and wholeheartedly that he pushed it through the window to gain access into my house.
Why do you believe that?
He didn't have a key and he was standing in my room right next to the air conditioner with the window open.
Was there anything outside that helped support your conclusion?
When the detective or the officer had showed up, she did recognize footprints leading up to my window in the backyard.
Objection hearsay.
What a response to the objection.
I'll rephrase your honor. Did you look around outside in your backyard?
I did not prior, no.
After this incident, did you look outside in your backyard?
I did not until the officer had let me know.
Okay, after the officer let you know, did you go outside and look?
Yes, I did.
Okay, did you see anything outside your bedroom?
It was my daughter's flag that was pushed up to my window and the footprints that she had spoke about that were large.
Okay, so you saw the footprints then?
Correct.
And the slide up against your window, is that where you ordinarily keep it?
No.
Where do you ordinarily keep it?
It's by my back door, which is far to the left side of my house.
So as you're looking at the back side of your house, the slide is ordinarily kept to the left of
Far
where your
left.
bedroom window is?
And my bedroom is on the far right on the other end of the house.
So based on your own personal knowledge of how your backyard is ordinarily kept, did it appear to you that that slide had been moved?
Yes.
What was the condition of your bedroom?
I didn't notice anything out of the ordinary other than some money missing and my exam missing.
Okay. You said there was some money missing?
I did, yeah.
Did you report that to the police?
I did also, yes.
Okay. How much money was missing?
It was only $20 at the time.
It's what?
It was $20 at the time.
Where were you keeping this money?
I left everything at home, so I just went my friends in my wallet and stuff at the house was in my wallet.
Okay.
Which was on my bed. I noted that to officer as well.
And so while you were out of the house, the wallet was on your bed?
Yes.
Okay. Did you notice anything else missing?
No.
Was there a mess in your room?
No.
Did you notice anything damaged other than the air conditioning unit?
No.
Was the air conditioner operational after that incident?
It was, it just had a like a rumbling to it kind of at first.
Does it still work?
Yes.
Okay. Okay. No further questions.
Dr. Chen.
Thank you, Your Honor. Good morning, Ms. Shook. I'm gonna ask you some follow-up questions. Can you just let me know if you need me to rephrase it?
Okay.
Okay, thank you. I guess I want to clear up the timeline of this event a little bit, okay? We talked about October 27th, is that right?
Correct.
Okay, now, is it that would the incident that happened, was it the 26th going into the 27th or the 27th going into the 28th?
I believe it was the 26th going to 27th.
Okay, Saturday into a Sunday?
I believe so.
And so if you showed up at your house just before midnight, that would have been October 26th, right? Okay, but if you showed up just after midnight, October 27th. Now you testified at first on direct examination, you thought maybe this was around 8 or 9 p.m.
That is exactly how it is.
Okay. You remember talking to a police officer in the early morning hours of October 27th?
Yes, that's when she showed up.
Right. She showed up quite a bit later, right?
Yes, it was hours later. She had showed up. They were really busy.
And in fact, you had called even a few hours after noticing Mr. Scruggs in your home, is that right?
Correct.
You remember telling the officer that it was around 11:30 or 11:40 or midnight when Chase came in?
Like I said, I don't remember the exact time. I was really stunned when I seen him, so I wasn't looking at my phone at the time.
Sure. But do you remember telling the officer that it was around that time?
It could have been around that time. Like I said, it was evening and stuff. I did get dropped off late.
If you were to see a portion of your conversation with the officer, would that help refresh your memory about when you told her that Chase came to your house?
I mean, I believe you.
But
Sure, if you want me to look at it, yes, I would.
Your Honor, logistically, I have a video. Would you prefer I put it up in the screen to refresh your memory or to
A video is a body cam or anything?
body cam?
That's fine, doesn't matter. You're trying to refresh your recollection of what time you called?
That of when she's saying that my client.
Oh, you can take the computer out.
This is to refresh your memory? Yeah, that's fine.
Mr. I'm playing you a portion of the interview. You're going to be able to hear it, but this is really just to refresh your memory about when you told the officer that Chase got there. So after watching it, starting at 4 minutes, 40 seconds, it'll go for a little bit. I'll pause it, and then can you just let me know if that refreshed your memory? Okay. Quiet to start. Hold on a second. I'm pausing at 5:16. Did that refresh your memory about what you told the officer?
Yes, like I said, it wasn't late at night.
And so in seeing that, did that refresh your memory that you told the officer that it was around midnight, maybe 11:30, 11:40?
Yes,
All right. And were you looking through your phone to try to figure out the time?
yes, I was.
All right. Do you remember what specifically you were looking at that time?
What time I had called 911
Well, okay.
is what I believe I was looking at.
But you called 911 a few hours after Chase was there, right?
No, I called shortly after, and then she had showed up hours after. So, like I called hours after, I mean, maybe like an hour after, maybe, but it wasn't too long after, and then she had showed up about early in the morning.
You saying the officer showed up
Yes, ma'am.
hours later?
Yes.
So you did not call 911 at around just before 3 a.m.?
I may have, that was the actual original call.
All right.
Like I said, it wasn't too shortly after.
If I showed you some records that from dispatch, which is where 911 calls go, would that help refresh your memory about when you call 911?
Your Honor, I'm just gonna place a relevancy objection at the moment. Just with respect to, I think the line of questioning is supposed to flesh out exactly what time the 911 call was made. I'm not sure the relevancy to the overall case here.
Well, two things, Your Honor. I think the timeline of events is always relevant, but also Ms. Shook just testified that she called 911 right away. And so if nothing else, as a matter of impeaching credibility on that point, should be able to see this.
Okay, but the objection's overruled.
Okay, thank you, Your Honor.
So if I showed you call logs from when you called 911, would that refresh your memory about when you called 911?
Yes.
May I approach you? Your Honor, may I?
Yes.
Okay. Just look at that top page. You know when you've had a chance to review.
Yeah, but at 2:52 in the morning.
Does that refresh your memory about when you called?
Yes, it does.
Okay, and is that when you called about 2:52 in the morning?
Yes, the officers always come in as long as I make contact within 12 hours of something happening. at the report house. My phone might have been dead at the time, which I'm pretty sure it was, and I did reference that to her, so I called after.
Okay, you think your phone was dead at the time?
I'm pretty sure it was. Once
So-
I had got home, I charged it and I took the shower.
So you were not-
But I definitely called within the time frame that I should have.
So you weren't calling Chase hundreds of times on the night of the 26th to the morning of the
Not
27th?
after that, no, I didn't.
No?
Not that I recall, not after.
Prior to that?
I may have,
Prior to what? So
Oh,
I can
I'm
have
sorry.
context.
Yes,
Prior
I'm
to-
sorry. Prior to spotting him in your home,
I don't remember. But I still didn't get some permission to be in my home nonetheless.
I understand that.
That wasn't a question, ma'am. Strike that. What, my question though is what, when you say you may have called him prior to, what time frame are you talking about, ma'am? When he asked you if you had called the defendant hundreds of times, he asked prior to, you said you may have, and I'm trying to get time frame.
I don't remember.
You don't remember when? Okay.
And then it was, again, a few hours after even you called 911, that an officer showed up, right?
Is that a yes?
Yeah.
Just for my clarification, you refresh your recollection, it was at what, 2:52
2:52
in the morning, AM or PM?
AM. Your Honor.
Okay, thank you.
All right. Now, among the things you noticed, you saw my client where at in your bedroom, is that right?
Standing right in front of my window in my bedroom.
The window to your bedroom, which again is along the back side of the house.
Yeah.
All right, and you noticed $20 missing?
Yeah.
And you say you reported that to the police?
I should have. I mean, I was also distraught. I don't know what all I mentioned, but she seen my Santa on the window open and went around the house and looked at everything.
Well, you testified on direct examination that you did tell the police that there was $20 missing, right?
It was in October, I don't remember, but I know I did have $20 missing.
You said you saw footprints in your backyard after the officer,
Yes, she pointed them out to me
okay, pointed them out how?
with a flashlight. And told me that she had seen footprints back there in my house slide up against my window.
So
That
the
was
two-
open.
I'm sorry, the two of you went in the backyard together?
She had shown me out of my window since it was open.
Okay. So, and then you noticed there was a slide?
Yeah.
Okay, that was something you observed?
Yes,
With-
she said she moved it back from me.
Okay. But on direct examination, you said that you saw the slide behind your window where Chase supposedly broke in, right?
Yes, once she mentioned it to me, I did see the slide right there.
Right outside your window?
Yes,
Not where she moved it back to?
it was right outside my window still, and she said she moved it back for me. She did take photos.
Have you seen those photos?
I haven't.
Might come back to that in just a moment. You said that you come in, you see Chase, right?
Yeah.
And he just walks past you out the front door.
Yes,
Was there any conversation?
no,
Was it understanding the air conditioning unit was out of the window, was you didn't notice anything else out of place?
no. I was also shocked and moment of seeing him standing in there. Paying too much attention other than that, to stuff right away.
Well, not right away, but you had hours to observe the scene after you
Right, I
left.
did, yes, so I
Okay.
didn't notice anything.
Okay,
You didn't notice anything, is what you said?
I did not notice anything, though.
Right, and the AC unit, did you end up bringing that out of your bedroom to the living room?
It, yes, I did. I
Okay.
did. Yeah, I drug it out there.
Okay. And
So,
just to,
just to get out of the way. Yeah, and I was gonna close my window.
okay,
So, but then I wanted to wait for him to report.
and that, this was again, October 27th. Was it still warm out? Do you know? Do you remember?
I don't recall.
I guess, let me ask you this. Do you normally take your window unit AC out of the window when it starts getting colder?
Yes, I usually don't have someone do it for me, so at the time I was waiting for someone to do it.
You said you lived alone at this home, is that right?
I do.
All right, and you do have a dog, right?
I do not anymore.
At the time?
Yes, I do.
Okay, what kind of dog?
I had a German Shepherd.
All right, is that German Shepherd no chase?
Yes.
Was that dog friendly with Chase or?
He was, yeah.
Right, so. Did
I
you have?
had a dog at the time. But he was not friendly.
You had to lock up a dog
Yeah.
when the officer came to ask you questions, right?
Correct.
The dog was barking like the entire time, right?
Not when he was there.
So was the dog with you when you were out and about?
I don't remember.
Okay. I get, when you go out, you were out with your friends before coming home around midnight, right? Do you normally take your dog out with you?
Okay.
Okay, so you don't remember if your dog was with you or not with you?
I don't recall, I'm sorry.
Okay. Do you remember the officer asking you if you'd been in contact with Chase in the days leading up to him breaking in?
Yes, I do.
All right, and do you remember telling her something to the fact that your last conversation had just been a few days beforehand?
Yeah, it was quite a bit beforehand. There was a lot of arguing back and forth, so our conversations weren't too consistent.
I'm sorry, could you say that again?
Our conversations weren't very consistent at the time. Arguing back and forth a lot.
Well, you told the officer that you hadn't been arguing in the days leading up to the invasion, is that right?
We go back and forth, we've been arguing, so like I said, it's kind of back and forth, either we're on good terms or we're on bad terms.
But, so I mean, your testimony here, though, is that in the days leading up to October 26th, October 27th, you were arguing.
We may have been, we may not have been, I'm not
Well,
sure, like I said, we've been good and we've been bad.
But you testified earlier, like
Your Honor, I'm
a
gonna,
minute or two ago, that you were arguing.
I'm going to object. This is asked to answer.
Well, no, I think it was not. I answered clearly. And I think that's why he's trying to clarify. She answered one way and then now I may have or may have not. And this all goes to her credibility.
No, I understand, Your Honor. I just.
Correct. So the objection to rule.
Thank you.
So you testified 2 minutes ago, if that, that you had been arguing with Chase in the days leading up to this home invasion, right?
But we may have been,
Well, that's not what you said at first, though, is it?
like, it was in October, so I don't recall. It was tiring.
Okay,
And
and
I
that,
apologize for that. We bickered back and forth, so I can't tell if the days following back in October, if we were on good terms or if we were on bad terms.
do you remember telling the officer who was there interviewing you on the morning of the 27th that you had not been arguing with Chase in the days leading up to this home invasion? I have the HDMI cord.
You actually need to log into the Zoom. The HDMI
Oh,
doesn't work.
okay.
Yeah, you log in and I'll give you
Okay.
permission.
Oh, yeah. Oh, you got, okay. Number spreadsheet. That's right. And I turned off the audio on my computer, like the volume.
You just need to keep your Zoom muted. When you share, did you click share audio? So if you probably didn't click share audio, exit out the share. And then when you go to restart the share, there's a button, so you just select share audio.
Thank you, Your Honor.
No problem.
Okay, and so we've had a few minutes delay while I'm trying to get the technology working. Where we left off is you did not remember if you told the officer that you and Chase had not been arguing in the days leading up to the home invasion, right? Okay. So I'm playing part of that video starting at 5:30.
Conversation.
Thursday, he was at my mom's house with me.
Okay.
Well, he just showed up there.
Okay.
Because I had the kids there. And he came to see his daughter for a little bit and then left. So that was like the most recent time we like seen each other in person and had a conversation like in person or
Yeah.
anything. Which we didn't have an argument then.
Like it was chill.
Yeah, I mean like we didn't really talk much.
Yeah.
But there wasn't.
But there was like no animosity. Yeah, there was like nothing crazy. And then, have you guys like texted or anything since Thursday?
A little bit, but not like an argument. I know that previously he did come to my house and like take stuff out of my house, my friends.
All right, so you told the officer that you'd had a little contact with Chase between the Thursday when you two were visiting your child at your mother's house and then the day of the home invasion, right?
Correct. Between then we did not have an argument.
What's that?
Correct. Between then watching them, we did not have an argument between then.
All right, now did you leave a voicemail on Chase's phone on October 25th threatening to kill him?
Not that I
You said not that you recall.
I don't remember.
Around this time, did you, well, what, and I don't want to, fair to say you have a couple matters going on over at the circuit court on Kalamazoo. Is that right? Okay, I don't want to get into the details into those, but did that lead to a custody dispute between you and Chase?
Not necessarily.
Right, well, what was the situation with your shared daughter?
She was placed with my mother because she said you cannot care for her.
And again, we're not going to get into details, but the daughter wasn't with you either, is that right?
Correct.
Now, did you learn right around the time of this home invasion that Chase was trying to get sole custody of your daughter?
I did not. I was not aware of that.
Did you learn that well, prior to that, did Chase owe you child support?
Yes, we did.
All right, did you learn around then that child support was gonna be inverted? Now you would owe child support?
Yes, but they revoked it since he hasn't had her at all.
And she's with your mother, is that right?
Correct, he
But-
does not see her.
I'm sorry. I interrupted. Can you say that again?
He does not see her at all.
The question was, that she's with your mother?
Yes,
Okay.
yes, she did.
Um, But there were some custody issues right around the time of this home invasion complaint, is that right?
Not necessarily, he was threatening to make sure I didn't see my kids ever again. That was about the only dispute we had.
Sure, that's all I have, Lori. Thank you.
I have a question. You said that when you saw Mr. Scruggs in your home, that no words were exchanged and then he walked out.
Yes, Your Honor.
Did you report that he shoved you at all?
He might have brushed past me when I walked by, but I don't think it was intentional.
Yeah, but that wasn't my question. Did you report that he shoved you?
I don't recall.
You can,
Thank you, Your Honor. So, just briefly, I think you on cross-exam, you were asked a lot of questions about some of the details with respect to what you reported.
Yeah.
Is it fair to say that October was a long enough time ago that you don't remember every detail?
It's not only that, but it's also there's been a lot of stuff going on between me and him, where it's been a lot of intense police reports, you know, stuff like that. So I don't. It's hard to recall everything of every
Okay.
situation that's occurred.
Okay, fair. On cross, there was some testimony about an ongoing custody issue between you and the defendant, and I'm sorry, it was your daughter, correct?
Yes, so
Okay, and because you share a child in common, you've had regular communication with the defendant regarding your child, is that fair to say?
I have tried, yes.
Okay, and you said you don't remember, I think on cross, you mentioned that you don't remember calling Mr. Scruggs after finding him in your bedroom, is that right?
I don't believe I did. I might have, but I don't recall. It was a while ago. There's been a lot going on.
Sure, fair to say. If I were to show you your statement to the police that night, would it help refresh your memory as to whether or not you've tried to do that?
Yes.
Your Honor, may I approach?
yes.
Okay, so I've marked on this police report, the part of your statement to the police that night. That might help refresh your memory. If you can just look it over silently and then look up when you've finished.
Yes, that makes sense. Yes.
Does that help refresh your memory, ma'am?
Yes.
Okay, so, all right, after having looked at your statement to the police, do you recall whether or not you tried to call Mr. Scruggs after you found him in the bedroom?
Yes, like I said, we didn't have any conversation. He just walked out and left. So I was ranting his wife and Dan startled, and that's not initially why I didn't call the police. I was trying to figure it out, and then I was looking at my house.
So when you tried to call him, did you have a conversation with him about why he was in your room?
He did not answer. No,
Do you recall whether or not you had called him more than once?
I don't remember.
Okay. But again, this is back in October, it's 4 months ago.
Mhm.
There's other ongoing issues with him. Is it fair to say that?
And a lot more, yeah.
Okay. But let's just say straighten the record out one more time. You testified on direct exam that you did see Mr. Scruggs in your bedroom after returning home.
Absolutely.
Mr. Scruggs did not have permission to be in your bedroom or in your house at that time, correct?
Absolutely not.
And when you were looking through everything after he left, you discovered that $20 was missing from your wallet. Is that
Yes.
correct? And that was your wallet, not Mr. Scruggs' wallet?
Correct.
And it was on your bed?
Yes.
And you have no other reason to believe anybody else but Mr. Scruggs would have left your home with that $20. Is that
That
correct?
wasn't the first time. Yeah. Yes.
Thank you, Mr. No further questions. Your Honor.
I have another question. So you said after you saw him, you tried to call him?
Yes, I did.
He didn't answer?
No, he didn't.
Okay, but when you were questioned by Mr. Coons and he asked you about calls, you said that your phone was dead.
It was, I don't remember exactly what time I called Chase. but I know my phone was close to dying because I did plug it in when getting back from my friend's house.
And then I asked you too about, he asked you about calls prior to or during that time frame, and you say you didn't recall, and I asked you too. So are you now having a greater recollection?
I didn't recall until he showed me the police report of me, letting the officer know that I did call him after to see why he was in my home.
Okay. Mr. Kuntz, any read across based on my questions?
Just briefly, so Chase didn't answer any of your calls, that's right?
No.
Sorry, let me rephrase the question. Is it your testimony that Chance did not answer any of your calls?
I
All
don't believe he did.
right, and you didn't have any other communication with him in the early morning hours of the 27th?
No.
Not even driving by his mother's house?
I don't believe so.
Okay.
I don't recall, I'm sorry, like he said, it was a while ago, there's been a lot going on, but a lot.
All right, that's all, thank you.
Question on the PA 53.
On the PA 53, Your Honor?
Correct.
So, yes, Your Honor. Ms. Shook, do you recall calling the police on February 14th of this year?
Yes, I do.
All right, and what was the reason for that phone call?
She just had called me that day, around about 1:34, 1:35 p.m. He made a phone call to me from his phone number.
Okay, so I think I think you started answering my next question. How do you know it was him? Oh, you're fine. That was a good answer. And you said it's from his number. How do you know it was his number?
It was, I don't have it saved, it was his, and when I clicked to go to the messages, it was the messages previously that he had texted me asking if he should knock on my door and introduce himself to my friend.
So this was a number you recognized that belonging to Mr. Scruggs?
Absolutely.
And this is and because you had testified before that you have a child in common, you communicate regularly with Mr. Scruggs about your child?
Yes, but this is after the PPO was in place.
So on February 14th, there was a PPO and this matter was pending before the court, is that correct?
Yes, correct.
And is it your understanding that there is a no contact order against Mr. Scruggs precluding him from contacting you while this case is open?
Correct.
And so when that phone rang from that number, you recognized it as belonging to Mr. Scruggs, with whom you have a child in common, with whom prior to this matter and prior to the PPO, you've had regular contact with him regarding that?
Yeah.
And it was at that number?
Yes, I did not.
Did he leave a message?
No.
Did he call you or text you after that?
No.
And that was your report to the police with respect to?
Yes, aside from his mother texting my mom, I had let him know that also because he had asked me.
Okay. Okay, thank you. No further questions, John.
Ms. Schick, do you have your phone with you in court?
I do, in my bag.
Okay, would that show that there's a missed call from Chase?
Yes, absolutely.
Okay, did you provide proof of a missed call
Yes, I
The go-
submitted it to evidence to K Brooks.
to evidence.com?
It was a link sent to me. I submitted the photos of his mother texting my mom like he asked, and then the phone call from him like he had asked me to.
Okay, you uploaded all of those?
Yes, and I still have it in my phone.
You uploaded, you said the text messages too?
Yes, I did. Yes, he asked me to send a screenshot of the phone number and then the messages to prove that it was him calling.
When did you do that?
It was the same day.
So on the 14th?
I had called, yes. He sat outside my house, and so I had provided the photo.
Yeah. You said the officer stayed outside your house until you provided photos?
Yes, he sent me a link while sitting outside of my house.
And
And
then,
said he was going to track his GPS further.
okay, and then was it your testimony that the officer waited until you uploaded photos before he left?
I mean, I would believe so. I was sitting on my couch watching him. And he sent me the link as I was sitting on the couch.
Okay, that obviously has not been turned over yet. Is that what's going on?
Well, Your Honor, so I received this report yesterday afternoon. I checked Axon under this police report number. There's nothing shared with me. It doesn't mean it's not there. It just means that their admin hasn't shared it with our office and been shared with me. But because I just received this report yesterday, I haven't had a chance to follow up and make sure that I was given all whatever was uploaded to Axon. I'm sorry.
I did bring a police report with me.
I have the police report. That's fine.
Yeah, we have the police report. It's the evidence is what we need.
Yes, sir. And that's prior to beginning today, that I want to share with you, the only thing I have for today with respect to this PA 53 is the witness's testimony.
Sounds good. And I move forward with her testimony today because she's already here and that avoids me having to resubpoena her back.
Oh, of course, yes. Just with respect to this evidence, I can follow up on that and if the court would prefer, I have no problem coming back with that evidence and sharing with it, to share with the court.
Sounds good. That evidence will already have been turned over to Mr. Koontz before then. Any other questions for this witness today?
No, Your Honor.
No, Your Honor, thank you.
Okay, and this witness be excused.
Yes, Your Honor.
Thank you, ma'am. You may be excused. You have another witness?
No further witnesses, Your Honor.
Okay, I'm inclined to adjourn now until the evidence on the PA 53
Yes, Your Honor.
is turned over. Reason being is I took testimony on both the underlying offense and the bond violation from one witness. And maybe candid, I do have questions and concerns about the overall credibility of that testimony. So I think flushing out this next set of evidence might help answer some of the concerns. I don't know if there was just a lack of memory on some things, or if there's an intentional lack of memory on some important facts. If someone asks me if I called someone and told them I was going to kill them, my response is not going to be, I can't recall. And so because there was so much back and forth on timelines and events and whether or not you call the police immediately when it happened or 3 hours later, and was your phone dead or not, that will make some gray areas for me. I would rather have some more evidence turned over to flush that out. If we need to resubpoena her, we can do that. If we don't, then we'll just proceed to argument at the next date.
So, Your Honor, I was there, and I know this is not common, I planned on having my client testify and introducing exhibits.
You want to do that today?
Well, we're gonna come back anyway, Your Honor, so I guess I'll defer to the court. If we're gonna have to come back anyway, if the court wants to hear our proofs today.
We can take your proofs today.
Okay, all right, thank you, Your Honor.
You can call your witness.
I call Chase Scruggs to the stand, please.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can have a seat. And I'm going to have your attorney voir dire you or question you about your right to remain silent, okay?
So Chase, you understand you're accused of some crimes here?
Yeah.
All right, we've got 2 accusations in this file, 1 home invasion, 2 domestic violence. You understand that?
Yes.
You understand those are serious offenses?
Yeah.
All right, and then there's another case that has 2 other allegations against you. You understand that?
Yeah.
You understand that in relation to all of those allegations and anything you possibly could be charged with, you have an absolute right not to incriminate yourself?
Yeah.
All right, and that means you do not have to testify in this case. You understand that?
Yeah.
And if you don't testify, your silence can't be used against you. Do you understand that?
Yeah.
Now fair to say we've talked about whether it was wise or not to testify today?
Yeah.
All right, and I've given you some advice on this.
Yeah.
Okay, and all that being said, is it your choice to testify today in your own defense at the preliminary examination?
Yeah.
Is the court satisfied with that waiver? Okay. So, Chase, I want to take you back to mid to late October 2024, okay?
Yeah.
All right, specifically on October 26th, 2024, did you break into Olivia Shook's house?
No.
October 27th, 2024, did you break into Olivia Shook's house?
No.
Okay. Now, did you have some contact with Olivia Shook in and around those dates?
Yes, a lot of repeated phone calls.
Let me stop you there. So you say yes, and a lot of repeated phone calls. Putting aside the phone calls for now, had you seen Olivia within a few days of October 26th to 27th?
Yes, we have regular visits every Monday and Thursday of our joint daughter, Zola Scruggs, at the mother's house.
And so Olivia's mother has guardianship of Zola, is that right?
Yes.
All right, and so you had seen each other you and Olivia had seen each other in that joint visitation on the Thursday before this alleged home invasion?
Yes.
Okay. And that would have been the 24th?
I believe so. I was looking at the calendar.
How do you recall that? I mean, was it a pleasant visit, unpleasant?
Very pleasant. I had brought my daughter, Alana Scruggs, with me. She usually attends the visits, but she enjoys seeing her younger sister.
They're half sisters?
Yeah.
Technically.
But they're full sisters. I would preach that, but yes. Everybody got along. Her mom was aware. Like I said, I've been to every visit that's been scheduled since the visits were instilled. Everybody, had normal conversation. Her mom had normal conversation. The kids played. It's usually from 5 to 7 p.m. With our allotted scheduled time.
And shortly before that day, Thursday, October 24th, had you taken any action with a friend of the court?
We were kind of going through everything. A lot of me and her mom was, that she has the guardianship, trying to figure out how to get those necessary Medicaid, keep her in school, and things like that. I wasn't very privy to everything that was going on with her case, because there was a couple different charges and dates.
Right. So, and we're not going to get into it, but again, Olivia's dealing with some stuff down the street on Kalamazoo, and you're aware of that?
Vaguely.
Okay. And we don't want to talk too much about that, but you're going through Olivia's mom. Is that Sarah?
Yeah.
Sarah Smith. All right. You're talking to Sarah Smith about taking care of Zola.
Yeah.
All right. And at that, well, in the months before October of 2024, were you paying child support?
Yeah.
Okay. That was court ordered?
Yeah.
All right. And then did that change at some point?
Yeah.
When did that change? Do you know?
Around the time these incidents happened, they had excused like the birth expenses and things like that. And we're now transferring over the amounts that I was paying, and she was supposed to pay them going forward.
All right. Now, made mention of some phone calls. In the days after that October 24th, 2024 visit, did Olivia call you?
Yes.
A couple times or more than that?
At one point, I had counted close to 900 calls within a 3-day period. It might be more. After just going through them, that was just kind of a quick count of what I had.
Did Olivia leave you any voicemails in that period of time?
Yes, on October 25th.
So she left you a voicemail.
Yeah.
Right? And let me ask you this before we get into the evidence. Do you have Olivia saved as contact in your phone?
Yeah.
How do you have her saved?
Crazy.
That's the contact name.
Yes.
You understand that could be taken as in poor taste to label someone as crazy in your contacts.
Yes, but I felt it was appropriate.
Okay. Did you go through your phone to find any evidence of these calls?
Yeah.
All right. Have you provided that to me?
Yeah.
Sure.
Oh, I'm sorry. This is not- So. I don't understand. Well. It looks like, I can't figure out what this is trying to say. It's. No. Okay. But this is a call from 2 days before the approval. So. I think I understand that this is going toward credibility. I'm going to object to this evidence as being irrelevant to the home invasion. However, I'll defer to the court's ruling.
I don't even have a clue what the evidence is.
Yeah, I'm going to object to this evidence, but I'll allow.
What's the evidence?
Your Honor, if you recall, Ms. Shook testified she did not recall whether she left a voicemail threatening to kill my client on October 25th.
Sounds like.
I plan on introducing evidence, both of the actual audio, but then also the little transcript that pops up in the voicemail application.
Visual voicemail.
Just to put a date and time on it.
But I think it's improper impeachment because the testimony was that she doesn't recall. She's not denying that these things happen. She's just saying that a lot has happened. She can't recall when something was done and when something hasn't. So I think this would,
right, and to the extent, well, I don't know that because she can't said because her response was that she can't recall that this would make it improper testimony because you can still be lying about not recalling. And if the evidence is that there were 900 calls when she was asked if she made calls, she recalled. You didn't forget 900 calls. Like that's a lot of work.
Well, I mean,
and then if the question that struck me as concerning was whether or not she had called and left him a voicemail threatening to kill him, and her response wasn't no. It was I don't recall. Threaten to kill somebody, typically, I don't know. I would remember if I threatened to kill somebody. So unless there was something and she wasn't questioned about whether or not there was something that's going on with her mentally or health-wise that would affect her memory, then I would believe that a reasonable person should be able to remember these answers or give an answer as to whether or not you threatened to kill somebody on a voicemail or not. So for the purposes of laying the foundation for impeaching the credibility of the witness, I'll allow him to proceed.
Thank you.
Chase, did I leave you a voicemail on October 25th?
Yeah.
All right. And did you provide the audio of that to me?
Yeah.
All right. And have you had a chance to listen to it yourself?
Honestly, not until everything kind of started. I never really listened to the voicemail.
But I, between, since this case began, you reviewed, you listened to the voicemail before providing it to me?
Yeah.
Is what you provided to me the same as what was on your phone?
Yeah.
You haven't altered it in any way?
No.
All right. Did you also take a screenshot of like the transcript of the voicemail? And you did that on your iPhone 16?
Yeah.
All right. And you sent that to me?
Yeah.
Did you alter it in any way before sending it to me?
No.
I move to admit defendants A and B on this flash drive. A being the transcript, B being the actual audio.
Okay, the objection was noted.
Thank you, Your Honor.
A and B is admitted.
Yeah, published to the court.
Yes. Are you still on Zoom?
Yes. Okay, so Chase, I'm showing you what's been admitted as defendant's exhibit A. This is the transcript that you sent me?
Yeah,
All right, what is the date and time?
looks like October 25th, 2024, 2:40 p.m.
All right, so that would have been the day after you had the visit with Zola.
Correct.
All right. And then, everything works on the practice. All right,
Bitch, you really got me so fucked up. Like, you literally fucking gave me some shit. Again, like, I'm so fucking pissed off at you. And I know you fucking lying about being at work. Because, first off, there ain't even no fucking things today. I have her on my fucking phones, too. Nothing was available today. And you even fucking told me last night you didn't have to work. You said you only had shit to take care of. He was like, I don't have to work. I told you I just had shit to do. But obviously it wasn't shit to do because you ain't even been ignoring my call. You just fucking muted my shit and put me on silent. So obviously you fucking with some bitch and you're busy being fucking laid up. Like, you dumbass fucking hoe. You dumbass bitch. I swear to God, yo, I'm gonna fucking track you down and when I see you, I'm gonna fucking kill you. Like, you weird as fuck. You dirty dick ass fucking hitting ass gay ass nigga.
all right, that was Olivia's voice in that voicemail?
Yeah.
That was her? Okay. Do you recall Olivia contacting you hundreds of times between October 25th and 28th?
Yeah.
Does that include like the hours around midnight of the night of the 26th going into the 27th?
Yes, they were constant. At the same time, not even minutes apart.
Your Honor, on the flash drive, I have Appendix C, which is, I'm moving to admit, well, I can lay a better foundation, but moving to admit the screenshots of these phone calls from October 25th to October 28th. And these have been provided to the people, I should say.
October 25th and October 26th. There's screenshots to show what again?
The missed calls.
Missed calls?
Yeah.
Well,
the calls missed.
Any objection?
I'll stand by my prior objection, Your Honor.
Okay, it's overruled. Defense, this would be C?
Yes, Your Honor.
It's admitted.
All right, you provide screenshots of these calls to me, is that right?
Yeah.
All right, and are the screenshots you provide me accurate depictions of what was in your phone?
Yeah.
All right, so I'm not gonna go through all of them, but I want to start with this one. Can you make out the date? Can you see that, Chase?
October 26th, 2024.
All right, and do you see, I mean, there are several missed calls on there?
Yeah.
All right, spanning from 5:33 PM to 8:42 PM.
Yeah.
All right, I'm gonna go to the next one. Also October 26th?
Yeah.
All right, also, I mean, a lot of missed calls between 8:52 and 9:11 PM.
Yeah.
And the next one, same date?
Yeah.
9:13 to 9:26 PM.
Yeah.
Next one, same date.
Yeah.
9:30 to 9:36 PM.
Yeah.
Next one, same date.
Yeah.
9:38 to 9:47. On same date. Two of them at 9:48.
Yeah.
Next one, same date.
Yeah.
Handful from 9:49 to 9:53.
Yeah.
Same date, 9:54 to 9:59.
Yeah.
Same date, 10 to 10:08.
Yeah.
Same date, 10:09 to 10:14.
Yeah.
Same date, 10:15 to 10:32.
Yeah.
Same date, 10:33 to 10:38.
Yeah.
Same date, 10:47 to 10:50.
Yeah.
Same date, two of them at 11:03.
Yeah.
Same date, three between 11:07 and 11:08.
Yeah.
Same date, three more.
Yeah.
Same date, quite a few more between 11:15 and 11:29.
Yeah.
Same date, 11:31 to 11:34.
Yeah.
Same date, 11:36 to 11:37.
Yeah.
Same date, 11:37, 11:41. Is that right?
Yeah.
Now, these are not missed calls. Is that right?
Yeah.
That did you answer these two calls?
Yeah.
All right, and it looks like you talked for a very short period of time on one of them.
Yeah.
All right, 3 minutes on another.
Yeah.
Do you remember specifically what you guys talked about?
If I had to guess, I was asking her to stop calling me. But we calls been going on all day. I was out getting the photos of our children, so I was trying to keep in contact with my mom and her mom, and I couldn't. With all the calls, like I didn't even get a call out.
Okay, fair enough. Did you, at that time, I mean, did you talk about being in her home unlawfully around that time?
No.
All right, next one, we got more, still October 26th, a bunch of calls from 11:45 to 11:56.
Yeah.
And then looks like another answered call at 11:57.
Yeah.
And then now we're into October 27th, right?
Yeah.
Got three missed calls, 12:02 to 12:04.
Yeah.
Same date, 12:04 to 12:14.
Yeah.
All right, and you heard Ms. Shook testify that you broke into her home around 11:30, 11:40 midnight, is that right?
Yeah.
Okay. But is it still your testimony that you did not break into her home?
Yeah.
Continuing with exhibit C, next photo, you see another missed call at 12:04.
Yeah.
And I want to say, you testified that you have Olivia saved as crazy in your phone, is that right?
Yeah.
Okay. Do you see a phone number on some of these screenshots?
Yes.
What is that number?
517-605-8665.
Is that the number you have saved for Olivia?
Yes, after she got her new phone.
Okay. Next one, a few more at the 12:47, 12:48.
Yeah.
All right, and then the next one, we see a handful of answered calls throughout the night, 12:49, 1:13, 1:54, 2:18, 2:28, 2:29.
Yeah.
Again, do you remember specifically, do you remember what you're talking about? Don't guess, do you know?
No, I can't say for sure.
But you did talk to her on the morning of October 27th.
Yes, we did.
Next one, we can't see a date on this photo, can we?
I think that's a continuation of probably one of the other photos. Some of them have 50 to 100 calls in there, so I had to break it down each time. So
Keep going. Did these calls continue throughout the morning of October 27th?
Yeah,
I mean, like, was it about this constant pretty much all night?
yeah,
In the 3 o'clock hour,
yeah,
in the 4 o'clock hour,
yeah.
in the 5 o'clock hour?
I would guess so. I wasn't asleep.
All right. Do you remember anything else unusual happening with Olivia in the early morning hours of October 27th?
She had continued calling, and I heard a horn outside of my bedroom window, from which I observed Miss Shook driving by my house, just laying on the horn, honking the horn, trying to get, I presume, my attention, for not answering her call.
You say you're home. Where is this?
1237 West Northwood Street, Lansing, Michigan, 48911.
All right, is that your home, somebody else's?
It's my mom's home.
Okay.
Who I've lived with since past 2 years.
About what time was this? Do you know?
The date that
That she drove, you said that.
October 27th.
Oh, okay. What time though? Do you know the time?
It was the early morning hours. I wanted to say it started maybe like 2, 3, between 4. I made 2 911 calls during that time as well.
Did you also get any video evidence of this?
Yes.
All right, of Ms. Shook driving past your mother's home?
Yes.
Did you provide that to me?
Yes.
All right. Is what you provide to me, well, what did you provide to me in relation to Ms. Shook driving by your mother's home?
Video evidence that I took, one from the top of my bedroom window, one from outside.
Right, and did you also send me any screenshots in relation to this?
Yes.
And what was the purpose of the screenshots?
To show the date and time of the offense.
All right, and this is in your Photos app on your iPhone?
Yes.
You did not materially alter any of those things before turning them over to me? I moved to admit defendants dependencies D1, D2, D3, and D4, which is.
Any objections?
Same objection, Your Honor.
Defense D is admitted over objection.
First, Chase, I want to open up. Right, I'm showing you D1. What are we looking at?
Miss Shook's car coming and passing my car that's parked on the street in front of my parents' home.
Is this a screenshot you took of one of the videos?
Yeah.
All right, do you see the date and time on there?
So here, no, but I know they were on October 27th.
It's probably 2 hours.
2:36 a.m.
On October 27th?
Yeah.
All right. And then we're going to go to D2. Is this the video?
Yeah.
From that screenshot?
That's one.
Now, you were a little far away. Were you able to recognize that as Ms. Shook's car?
Yes, the black Ford Taurus. At the time, I believe she had no license plate as well on the car.
And then you said there was another video you took from the street?
Yes, one a little bit closer.
All right, so looking at D3, is this a screenshot you took from that next video?
Yeah.
And when was that taken?
At 2:42.
On October 27th?
Yeah.
And actually, in that screenshot, no, it's a little blurry. Do you know who's in that car?
Miss Shook.
of Ms. Shook driving by?
Yes,
I have a question on this particular clip. Are you outside?
yes, I'm outside on my front lawn,
Okay,
so that way I could get a clear view of the car and Miss Shook.
okay, so the first one, it looks like you were inside the house?
Yeah,
or-
that's when I first, that was probably the second or third time that she
Right.
came by. The first time, like I said, I didn't capture anything, but I had a feeling that she may come back, so I wanted to try to get it on video.
Um, almost done, Chase. Did you talk about, or we talked a little bit about the custody issues going around the time of October, October of 2024, right?
Yeah.
All right, did you ever receive a friend of the court recommendation in relation to that?
I do believe I did.
Yeah, approach you on it. Chase, I'm just gonna scroll through a little bit. Does that look like what you would have received from friend of the court?
Yeah.
All right. And again, this is surrounding custody and child support of Zola.
Yeah.
Your Honor, I move to admit defendants F, which is again, custody, a front of the court recommendation from 30th Circuit.
An objection.
I don't see how this is relevant to the home invasion.
That's what I'm trying to understand.
Well, Your Honor, I think the court can tell that my crux of the case is that Ms. Shook is not a credible complainant, and
I'm gonna be frank, I don't think you need it.
I understand, Your Honor, but this just shows that what I plan on showing it is that this friend of the court recommendation was mailed out on October 24th, the same day of their visit, meaning the calls start the next day. Doesn't.
Okay, he can testify as to it. I don't need to see it.
Okay, thank you, Your Honor.
Okay. Chase, did you receive a copy of the front of the court paperwork around the time of all these phone calls and the alleged home invasion incident?
Yeah.
All right. Do you, only if you have personal knowledge, do you know if Olivia also received a copy?
I would say yes, because she responded to it with a letter to the judge.
Okay. Is that something you learned after the fact?
Yes.
All right, Chase, that's all I've got for you right now. Just as a reminder, the prosecutor did ask you some questions now.
Yeah.
I need to take a brief 5-minute.
All right.
Mr. Eagle. Okay, and Mr. Suggs, you're still under oath. Examination.
Mr. Scruggs, you have a child in common with Ms. Shook, not?
Yeah,
And you do not have custody of that child, is that correct?
no, not full custody.
So you have partial custody?
That's the legal rights to her.
When was the last time you saw your daughter? Don't remember?
Had to visit at last visit because after October 30th, we had another incident at my house. So Mr. spitting on me. So I contacted her mother and we decided that we were not going to do anything.
You say Ms. Shook spit on you.
Yes,
Was that in the same month of October?
yes, October 30th.
October 30th? Do you remember an allegation against you stemming from October 2nd?
Yes,
There's some harassment between you and Ms. Shook, correct?
yes,
You were sharing some pictures of Ms. Shook, correct? That was October 2nd.
yeah.
Who is Chase Hendricks?
That's my Facebook profile.
That's your Facebook profile?
Yeah.
Okay. Remember sending a message to Ms. Shook that you should have died in that car crash or during your surgery?
Yeah.
You sent that to Ms. Shook?
Yeah.
How is this relevant?
This is relevant with respect to the defendant's credibility with respect to the allegations he's making that he didn't do anything. This is just the witness making it up. So this
is, you're saying, I don't think he testified he didn't do anything. I don't think there's a dispute as to whether or not they had a contentious relationship. He said he didn't break into her house. How is this relevant to home invasion first and a domestic violence?
This is it's going against the defendant's credibility with his claim. It seems pretty clear that the defense in this case is that the witness here is making up these allegations because she's got something against this defendant.
Well, it's not just an allegation. They've just put on the record a countless exhibits that showed a timeline of phone calls. So unless you're telling me that this was something that took place during that time or somehow connects to this case, it's not relevant.
Well, this is all in the month of October. This also goes to
when in October.
The defendant just testified that this happened around October 2nd. So this has been 25
Not relevant.
days.
Move on.
The phone call that was placed that you played here, correct? You remember testifying that was her leaving a voicemail?
Yeah.
That was because you had given her an STD, correct?
No.
You had given her some sort of HPV and she was pissed off and calling you about it?
No, sir. I've actually gotten tested multiple times since then. On my test came back clear.
Okay.
I want to say my most recent one was probably November 20th, actually. At Forest Community Health Center.
Okay, you don't need to keep going into your protected health information.
So there was some testimony where the defendant says that she doesn't recall whether or not you had sent a message threatening her life, but do you recall sending her a message that says, And fair warning, don't try to be funny. And you got a girlfriend, or so you got a GM or GF, BM, Lil, yeah, or whatever, because it's a lot of whatever that is. Y'all wouldn't guess been down through there, or you seen my name in they phone. So keep it P, laughing face. I don't miss my shots too often. Don't make me get to shooting again. That Ben's parked in a neighborhood near you type shit. You remember sending that to her?
That wasn't sent to her, that was posted on my Facebook story.
That was posted on your Facebook story?
Yeah.
Was that intended for her?
No,
When was that posted?
When was that posted?
I can't recall off the top of my head, exactly when I posted it.
Was it before October 27th?
Yeah,
Was it around October 27th?
no,
If it's not related to this incident, I don't want to go through the history of their back and forth relationship.
Your Honor, it also goes to the defendant's mental state when it comes to why he would want to enter the home on October 27th. This is an ongoing issue where he's harassing the witness. The witness
He's
also.
harassing Mr. Nagle. I just had 900 phone calls.
Yes, Your Honor.
Let me stop you. I'm not going to sit here and let you try to go back in time till early October, September, and try to create something that shows, or if you want to read or to cross-examine him, you're gonna have to talk about the incident or something tangentially close to the incident. This is 900 calls that just came in around the same time. Not the same time, at the same time that your witness testified that he was in her house. The same time that she said he was in her house, I just saw evidence that she was blowing his phone up.
I saw the evidence too, Your Honor, but I believe the phone calls came in around 2:45, 3 o'clock.
No, I saw, we started at on October 26th, we went through the whole entire day. Back to back, minute on the minute, the same exact time that she claims he was in her house. She also claimed that her phone was dead. She also said she didn't remember if she called him. She also said that she was out with friends during the time that she's blowing his phone call up. And then I saw evidence, by way of video evidence, of where she's driving by the house, laying on the horn obnoxiously. And shortly thereafter, there's a phone call to the police.
The point here, Your Honor, is that this is an ongoing thing between the two of them. They're both.
I don't
to each
dispute
other.
that there's an ongoing thing between the two of them. What happened in their relationship that caused the demise of the relationship really is not relevant to whether or not he committed a home invasion. The only reason why those phone calls and things were relevant is because they dispute the timeline that she's giving. I do not believe that they had a relationship that was full of pleasantries and that he probably didn't say some things that was egregious. I don't care if he gave her STD or not. That doesn't mean that you get to accuse him of something that's not true. So unless you're going to show us where it was true by your cross-examination, showing me that he made a post October 2nd has nothing to do with what happened on the 27th.
It just leads up to that.
No, it does not lead up to that. Has nothing to do with it. Unless his post was, I'm breaking into your house on the 27th without your permission.
The people who arrest here, Your Honor, will come back about the PA 53.
I'm not moving forward with the PA 53 because I just there's zero credibility of your witness. Zero.
Understood, Your Honor. That's fine.
So you can try to restore your witness. I think she's still here, but that's up to you.
The people will arrest you.
Thank you. You can be removed from the stand, sir.
Just so there's a clean record, no redirect, Your Honor.
Thank you. Do you intend to give any argument?
Yes, Your Honor. Nothing offered by the defense vitiates whether or not the defendant was present in the home on October 27th. There's a long history between this defendant and the witness, going back a long time, where the both of them are harassing each other. I do understand that there's some credibility issues with the witness. There is some misunderstanding of, or not misunderstanding, but there is some inconsistencies with the timeline. But given the history between the two, I believe that question of credibility between the defendant and the victim should be better left to the jury.
The credibility of the victim is up to the judge today.
It is, yes, I understand. What I'm saying is because there's an issue of credibility, according to the people's position is that there's a question of credibility between the defendant and the victim. The people's position is that would be a question best left to the jury.
That's not consistent with the law. The law says the court is the sole determiner of credibility of the witness at the exam. Not that credibility issue should be fleshed out by a jury. Sole determiner is the judge, and that's today.
Understood.
Any further argument?
The people are ready.
Ever so briefly, Your Honor. People versus Anderson, 501 Mich 175. Says exactly what Your Honor is saying, that you are the trier of fact today. You make the determinations on credibility. I think we've got a pretty clean record about why Bishop is not credible and why there's not even probable cause to believe that Jay Scruggs committed home invasion or domestic violence. For asking for dismissal. Thank you.
Thank you. Today was the date for the preliminary examination. The burden was on the prosecution to establish that they had sufficient probable cause that the allegations of the felony, because we're not addressing the domestic violence, or at least we don't need to, although the domestic violence is going to be dismissed on the statements made by the witness anyways, that there was more likely than not a felony that was committed and that you were the person who committed the felony. So this is not an imaginary burden here. It's got to be more than mere suspicion. And it's based on the evidence that's presented today by way of testimony or other evidence. The court is the sole determiner of credibility at a preliminary examination. The burden is flexible. And the court also is in the position of measuring the likelihood that the evidence will raise reasonable doubt at the time of trial. That's part of my job today, not to just hear things and then decide that there's issues, but let it be flushed out at a jury. I've heard testimony today. We could go over the elements of home invasion, but the concern that the court has that is disturbing to me is that the evidence that was presented, it's very uncommon for a defendant to take this stand at a preliminary examination, period. The fact that the defendant took the stand and all this information or evidence that was supposedly turned over to the prosecution was not used to flush out the likelihood of the people's ability to sustain their burden, and that nothing was done in the interest of justice considering that information. There's no one, I don't think you need to have a law background to look at this evidence and see the glaring issues here in this case based on the timeline that's presented. I had testimony of one witness today, that being Olivia Shook, testified that she had been in a dating relationship with the defendant, Mr. Scruggs, and that on the date and time in question, that being on or about the 26th or the 27th of October 2024, that he entered her home without permission. There's also, based on the complaint, a domestic violence charge, and that's because she reported, or at least when the question asked her about, the court questioned her about reporting that he assaulted her or that he shoved her, because that was the information in the affidavit of probable cause leading to the court granting the charge. She stated that she may have reported that, but that she doesn't believe that if he shoved her, that it was intentional, or that he brushed up against her, that was intentional. The testimony that she gave today on direct was that she returned home after being out, and she wasn't clear on the timeline, that she was surprised to see Mr. Scruggs in her home, that he stared at her, or she stared at him, and then he walked out. And that the police were called, lit footprints in something to the effect of her child's slide was pushed up to the door or the window, and potentially how he gained access. And then that $20 was later found to be missing. It got very strange for me when the timeline got so conscrewed about what time the incident occurred and what time she called the police. It later was determined on cross-examination that she actually called the police at about 2:52 in the morning, which was contrary to the testimony she gave in her direct examination. The other thing that was concerning was that she alleged that the breaking and entering or the home invasion, I should say, took place at approximately 11:30 to 12 o'clock. If someone broke and entered in my home and assaulted me, I'm not waiting almost 4 hours to call the police. And she claims that, well, maybe her phone was dead, and that's why she waited to call the police. Then she testified that when asked if she had made phone calls to the defendant during this time or prior to this time, she said she did not recall. Then when asked her, her questions or responses about whether or not she and the defendant had been arguing or feuding during the days prior to, she wasn't clear then either. She can't recall much of anything. Specifically asked if she left a message voicemail for the defendant threatening to kill him. I can't recall. There was no testimony or evidence otherwise presented that would establish that she has a capacity or an issue in her brain that affects her memory or recollection of this incident. And I recognize it took place October 2027, but if I threatened to kill somebody or I called someone after they broke into my home and asked them why, I think I might remember some of those facts. But what's glaring is that the evidence that was submitted during the direct examination of the defendant demonstrates over 900 phone calls based on his testimony from the alleged victim to the defendant, starting, I don't know if it started the day prior, but the days that he presented in the video shows me at least all day the 26th, he's getting nonstop phone calls from the victim or the alleged victim. And I'm talking about every minute there's a missed call. There's no possible way under the sun you don't recall if you called him. When you called them, you know how much effort it takes to call someone that many times? You didn't forget. You intentionally lied to the court. On top of that, that timeline was provided to the prosecution, and the prosecution could have looked at the timeline and said, there's no possible way that he was in her house, or no reasonable person to believe that he's in her house at midnight or between the hours of 11 and midnight, because she's blowing his phone up the entire time during that time frame. Doesn't make any sense. And then she alleges she gets home, she had just gotten home from being with her friends, and then her phone was dead, but that's not the truth, because your phone wasn't dead because you blew it up. You blew up his phone using your phone. And then I see evidence where you're driving past the house that he's living in the middle of the night. The timestamp tells me 2:36. Multiple times you're driving by, glaring on the horn. There's a voicemail on or around that same time frame where she's upset about something. She believes that he's laid up with someone else. It's evident based on this that there's still some kind of relationship that was going on at that time. If she believes, based on the questions that was asked on the cross-examination of the defendant, that he provided or gave her an STD, they're obviously must have been still engaging in some kind of intercourse at the time. Nonetheless, she, during the date of the 26th or 27th, believed that he was lying about being at work. He's not answering her phone calls, and she believed he was with someone else, and that's why she's blowing his phone up. And she's going by his house at 2:30, 2:37, 2:40, up to 18 minutes before she allegedly called the police. She's engaging him by way of phone calls, repeated phone calls, and driving past the house, which is noted on video. I should also note that I revoked his bond based on an allegation that she made that he was driving past her house and that she has a video camera. I didn't see any video today that showed me that he broke into her house. But she obviously had video when it came time to get him arrested based on the allegation that the people can now not sustain. The people can't sustain any of this because it's contrary to the evidence that was turned over to them by the defense, and the people had a responsibility to dismiss this case and not waste the court's time. The timeline was clear. Multiple phone calls. There's zero question about her credibility. She lied to the court. She has maliciously prosecuted this person based on this lie. And I hope he takes recourse based on that. The case is dismissed.
Your Honor, the defendant is still on bond for a case set for trial in this court on April 14th against the same victim.
I can imagine. You all should discuss that off the record because I'm sure it'll come up about credibility issues. We'll get your dismissal in just a moment.
Okay, can I get a transfer?
Does the court want I removed the exhibits that weren't admitted from the flash drive. Does the court want that?
I do not. Thank you.
So, yeah.
Matter of the people of the state of Michigan versus Alberto Perez, 25-00288, council appearance.
Matt Nagle for the people.
Assistant Public Defender Sarah Donnelly on behalf of Defendant Alberto Perez, who is standing to my right.
Okay, this was the date set for a preliminary examination. This is for police officer fleeing third assault resisting obstructing officer. Are you ready to proceed?
Before we proceed, Your Honor, the people have extended an offer in this matter for the defendant to plead guilty to an attempted flee and elude fourth, a misdemeanor, and attempted police and officer assaulting and resisting obstructing, also a misdemeanor. That offer expires at the start of the preliminary exam. My understanding that the defendant has been presented with that offer and is choosing to decline, and so the people are prepared to continue.
That's correct, sir. Okay. If the offer is expired, you can call your witness.
You can call Officer Rogers.
You solemnly, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. You state your first and last name and spell both.
Catherine Rogers, KATHERINE ROGERS.
You can proceed, counsel.
Thank you, Your Honor. Officer, with whom are you currently employed?
The Lansing Police Department,
How long have you been employed with Lansing Police Department?
less than a year.
Less than a year. Okay. What are your responsibilities with Lansing Police Department?
I am an officer of the law,
What do you do for Lansing Police Department?
road patrol.
Okay. And what are some of the responsibilities you serve as road patrol?
We take calls from dispatch and we try to limit crime.
Okay. Do you also monitor traffic
Yes,
for traffic offenses?
yes,
Okay. And were you working in this capacity on January 31st of this year?
yes.
And were you working by yourself at that time?
No,
Who was with you?
Jake Ellis.
And who is Jake Ellis?
He is a FTO I was riding with,
What does FTO stand for?
field training officer.
Okay. So there were two of you working together on January 31st?
Yes,
Do you recall attempting to make a traffic stop that night that resulted in a fleeing?
yes.
Can you tell the court about that, please?
We were on North MLK and we had noticed a plate on a gray Porsche that was expired. We ran it. It came back to a BMW. It turned west onto Oakland.
Okay, so the plate was
Yes.
improper? Okay. And then you said the vehicle turned west onto Oakland?
Yes.
Once you noticed the plate did not belong to that vehicle, what did you and Officer Ellis decide to do?
Initiate a traffic stop.
Okay, and had you done that before the vehicle turned west onto Oakland?
No.
Okay, so you followed the vehicle west onto Oakland,
Yes.
and then what happened?
Officer Ellis initiated the headlights.
Okay.
Or the upper beam on top of the patrol car
And what was the purpose of that?
to initiate the traffic stop.
Okay, and were you positioned close enough to this vehicle that from your perspective, the driver of the Porsche should have known that the traffic stop was being effected?
Yes.
What happened next?
After Officer Ellis initiated his lights, the vehicle continued on Oakland westbound at approximately 30 to 35 miles per hour. Did not slow down and continued on.
Okay, and was the vehicle doing the speed limit at the time?
I don't recall the speed limit for that area.
Okay, did you have any concerns at the time of this vehicle speeding? But you had initiated your lights, and from what you could tell, did it look like the vehicle? Strike that. Okay. So you saw the vehicle turn off. What do you remember? What road it turned off on?
Off of Oakland, it turned onto Kaywood.
Kaywood. And then what happened next?
The vehicle continued south on Kaywood, and then it turned into the driveway. I don't recall the address.
If I were to tell you 721 Kaywood Street, does that sound correct to you?
Yes.
Okay. Now, while he's driving into this driveway, was the overhead lights on your squad car on this whole time?
Yes.
And you were following him throughout this time?
Yes.
How close would you say you were to this vehicle with your overhead lights on during this period?
I'm not entirely sure.
Within so many car lengths, maybe could you guess?
I would say approximately 1 to 2 car lengths.
Okay, 1 to 2 car lengths and no traffic between you?
No traffic between us.
Okay, thank you. So once he pulled into the driveway at 721 Kaywood, is that still in the city of Lansing?
Yes.
Is that County of England?
Yes.
Okay. What happened next?
Perez then got out of the vehicle. Officer Ellis and I stepped out of the vehicle. Officer Ellis gave verbal commands. And then Perez had turned away from us and began to walk in front of his car. And we went after him.
Okay, let me ask you this, the squad car that you're in with the overhead lights, is that a marked Lansing Police Department vehicle?
Yes.
And how were you dressed that night?
I was dressed fully in my Lansing Police Department uniform.
And was Officer Ellis dressed the same way?
Yes.
So when you got out of your vehicle after that vehicle had parked, did you announce yourself as police?
I can't say what Officer Ellis said, but I had followed suit with him. I did not say anything.
Okay, fair enough, but you are dressed in your uniform?
Yes.
And what was the commands that were given to this person that got out of the vehicle? Do you recall?
I don't recall, and I can't speak for Officer Ellis.
Okay. Did you say anything?
I did not.
Okay. All right, so you saw this person walk in front of his vehicle? Did he acknowledge you at all?
He faced us and then turned away from us and began to walk away.
Okay. Did he say anything to you when he faced you?
I don't recall.
All right. Was he walking away or running away?
I don't recall at what pace he was moving away from us.
Okay, you don't remember walking or running?
No, I don't.
Okay. But he didn't stop, correct? Did you have an opportunity to catch up to him?
Yes.
All right, what happened when you caught up to him?
Officer Ellis had taken him to the ground, and then I held onto his feet.
Okay. Officer Ellis took him to the ground and you held him at his feet. Why was he taken to the ground?
Because we were placing him under arrest.
Did he stop when he was instructed to stop?
I don't believe so.
Was he told to stop?
I don't recall what.
So you would agree that people can be taken into handcuffs without being thrown to the ground, correct?
Yes.
You've been trained to do that?
Yes.
Did something happen in this case that required the defendant to be taken to the ground in order to put handcuffs on?
Yes, he kept moving away from us and would not. He just kept going and would not stop.
Okay. What, in your opinion, would have given him the impression that he had to stop?
Verbal commands.
All right, and what were those verbal commands? Do you recall?
I don't specifically recall what Officer Ellis had said.
Okay. Was he given a command to stop?
I don't entirely recall.
One minute. Were you wearing a body worn camera that night?
Yes.
around the time, around the time the subject and the Porsche got out of his vehicle, did you activate your body worn camera?
Yes.
If you were to view the contents of your body worn camera, would that help refresh your memory?
Yes.
Your Honor, for the purposes of refreshing the witness's memory, may
I think you're already in there.
am I already in there? Let's see. Okay, here we go. Recognize this?
Yes.
Is this your body camera?
Yes.
I believe when you activate your body camera, the first 30 seconds or so is of the recording is from back. So there's usually no sound for the first 30 seconds. Does that sound right?
Yes.
Incident assigned.
Okay. 32, we are really slow stop. We're running about 15 miles an hour south on Kaywood right now. Copy, slow to stop. Any units closer than 33?
Simmons just wants an ambulance. Your incident has been updated.
Start that way. You're at 32 stop.
I'm here. I'm not doing anything. I said I'm here. Hey, so I'm here, brother. Hey. I said I'm here. I'm not doing anything.
When the red and blue is going for you to stop your car, you stop your car.
Okay, I stop it right at my house.
No, you stop when I light you up at King and Oakland.
And what? Okay, I'm here.
32. You tried to run.
I'm not trying to run anything.
We were at
I feel like I was going to my house. I'm not running anything. I was going to my house.
Well, now you're under arrest, dude.
Okay, but I'm not running. I stopped right at my house.
Okay, so does that help refresh your memory as to what happened after he stopped at that house?
Yes.
Okay. So what we saw is when you got out of your vehicle, it looks like he was trying to get away from you. Is that how you would describe it?
Yes.
Okay.
This wasn't an exhibit, just to refresh.
Just to refresh, yes, Your Honor. And then, did it look like he was thrown to the ground, or did it look like he fell over while running away?
I wouldn't say he was thrown to the ground. But
Would you say it was pretty clear, based on what you were able to observe that night, that he was trying to get away from you?
yes.
One more second. The squad car you were driving, was that equipped with a camera facing forward?
Yes,
And that camera operates when the overhead lights are operated, is that correct?
yes,
And was your camera working that night, do you recall?
I believe so.
Would you recognize the camera if you would see it?
Yes.
Your Honor, I haven't downloaded this to a USB drive, but I would be requesting that this be admitted as People's Exhibit 1.
Any objection?
No, Your Honor.
People want to admit it?
Thank you, Your Honor. Public for the court?
Yes.
I am going to try to share my screen. So do you recognize this?
Yes.
Does that look like your the dash cam from your squad car?
Yes.
And do you see the date up there in the upper right-hand corner?
Yes.
Is this the date and time of the traffic stop that we're discussing today?
Yes.
Okay. I'm gonna play this. And so this would be North MLK, like you testified before, is that right?
Yes.
And I think he's gonna be making a left-hand turn up here. This is gonna be on to, is it, I believe it's westbound Oakland, is that right?
Yes.
Okay, so far the overhead lights are not activated, is that correct?
Yes.
And right here, you can see the red lights indicating that the traffic stop is congested, correct?
Yes.
And we can see the vehicle in front of it is not stopping.
Assigned.
35. Okay.
32, we are really slow to stop. We're going about 15 miles an hour south on Kaywood right now.
Copy, slow to stop. Any units closer than 33?
Simmons just wants an ambulance. Your incident has been
25,
updated.
start that way. 32 stop. But
Your incident has been updated. Yeah, it looks like the caller was at 10:35. That's it.
And is that a fair and accurate representation of what you recall happening that night?
Yes.
Were you able to get ID of this person?
I don't recall.
Did you run his name through the law enforcement information network?
Yes.
Did you check his ID?
I don't believe I did.
Okay. But you were part of the arrest, taking him into custody, correct?
Yes.
All right. And so I assume you would recognize him if you saw him again?
Yes.
Did you see him in court today?
Yes.
Can you point to him and identify an article of clothing that you're wearing?
He's sitting right there in the gray sweater.
Your Honor, I'd ask that record reflect ID.
Any objections to identification?
No, Your Honor, just for the record, she did point towards defense counsel table.
Identification is noted.
Thank you, Your Honor. All right, no further questions. Thank you.
Cross-examination.
Good afternoon, Officer Riders. You testified today that you've been with Lansing Police Department for, you said, less than a year?
Yes,
All right, do you have any other previous experience in any other departments?
I do not.
Okay, and have you ever testified in court before?
I have not.
So this is your first time testifying, all right. Your testimony was that you were riding along with your field training officer, Officer Jake Ellis, correct?
Yes.
So you would be in the front passenger seat.
Yes.
Okay. All right, and we saw on the video that that Officer Ellis initiated the lights on the patrol vehicle after defendant's car had turned west onto Oakland Avenue, correct?
Yes.
All right, and you said on direct, you said you didn't recall what the speed limit was on that section of Oakland?
Yes.
You don't. But you do know it's what? How many lanes across is it right there? You recall?
I do not.
But it's multiple lanes and they're all going one way, correct?
Yes.
All right. All right, and then we saw in the video where you said on direct that you estimated that, or the speed the car was going was about 30 to 35 miles an hour.
Yes.
All right, and you said you didn't slow down on Oakland.
Yes.
But it did the vehicle at all times while it was on Oakland speed up?
No.
Okay. So essentially it maintained speed until it turned, was it south on Kaywood?
Yes.
All right. And then per your video and per your on direct, you testified that it pulled into a driveway at 707 Kaywood. No, I'm sorry, 702 Kaywood. Does that sound about right? I think that was what you on direct, when the prosecutor asked you if he said that it was at 702 Kaywood, would you dispute that? Is that where the car pulled into the driveway? Do you recall that?
I believe it was a different address other than 702. It started with a 7.
Let's first.
Yeah. Oh, yeah, it does. Okay.
Yeah.
Same address.
All right, Your Honor, may I have approached? I'm gonna record here. So that you read it. This is your report. If you could let me know when you see the address that it stopped at.
Right here. Into the driveway of 721 Kaywood Street.
All right, so 7. Okay. All right, and at some point, did you determine or did you figure out that who that defendant lived at that address?
I don't recall.
Okay. We watched your we refreshed your memory with the video of your we watched your body worn camera video, or refreshed your memory with your body worn camera video. Refreshing your memory with that video, do you recall the defendant making exclamatory statements?
I don't recall.
Okay. Do you don't recall whether anything that the Mr. Perez was saying after you detained him?
I don't recall.
Okay. All right, so at no point during this interaction, before or after he's arrested, do you know who lives at 721 Kaywood?
I don't recall.
Okay. I would, I know that was previously used to refresh your memory. I would like to enter as defense's exhibit A, her body worn camera that evening.
Any objection?
No.
I gotta get. No, I got it. I was waiting for. I know, I need to be let in, but if you want, I was gonna start it at 1:46.
Okay. 1 minute 46 seconds. Oh, yeah, it's right here. She gets on.
My mouse button is dying. Did someone admit her because it's not letting me?
I was gonna let the prosecutor play. He's already still in there.
I did just.
Is that
I
why
think
you're-
I might need to change the batteries in my mouse. And I can make you co-host. Okay.
What?
Am I still sharing? Is that why you haven't?
Yeah, I allowed you to share. I don't know if I made you co-host, but I'll make.
No,
you-
I had to be let in.
Oh, I see. Here we go. Here we go. Oh, and then at 1:46, right?
Oh, yeah, yep.
Okay. So.
No. I'm here. I'm here. I'm not doing anything. I said I'm here. Hey, I'm here, brother. Hey. I said I'm here. I'm not doing anything.
When the red and blue is going for you to stop your car, you stop your car.
Okay, I stop it right at my house.
No, you stop when I light you up at King and Oakland.
And what? Okay, I'm here.
32. You tried to run.
I'm not trying to run anything.
We were at.
I feel like I was going to my house. I'm not running anything. I was going to my house.
Well, now you're under arrest, dude.
Okay, but I'm not running. I stopped right at my house.
No, dude. When the police light you up, you stop.
What?
On a traffic stop. You don't just keep driving
Oh,
and then get out of the car and try to run into your house.
okay. Okay.
Hold on. I'm trying to double lock these.
Okay.
The handcuffs don't tighten up on me.
And what?
I'm trying to lock these so the handcuffs don't tighten up on me.
Oh, okay.
Um. So Officer Rogers, on direct, we were trying to figure out if you could recall exactly what the verbal command that Officer Ellis gave Mr. Perez. After refreshing and viewing the evidence, did we come to did you recall whether you remember the exact verbal command that Ellis gave Perez?
I remember hearing him on the video, but in that moment,
You still can't recall what the exact command was?
no.
Okay, and you on direct said that you didn't say anything.
No.
All right. No further questions, Your Honor.
Redirect.
Just briefly, on, so on cross, there was some questions about whether or not we've checked to see who lived at that address, correct? Do you remember that? What happened to the vehicle?
I personally did not deal with the vehicle, so I don't know what happened with it.
Were you present when anything happened with it?
I was present for the search, but other than that,
Nothing, okay. You said you couldn't remember what the command was given because there wasn't, after watching the video, there wasn't really a command, was there? That you could hear? But there was kind of a, did you remember hearing something that
yes,
sounded
I
like?
heard Officer Ellis say, don't.
And that's about all we could hear, right?
Yes.
And it looks like from what we could see in the dash cam video of the vehicle that you were in, that at the time Officer Ellis and the defendant were looking at each other in that moment, right?
Yes.
And then you being present at the time, you recall after that exchange, the defendant moved away from you guys, correct?
Yes.
No problem.
I made this witness be excused.
Yes, Your Honor.
May be excused. Thank you. Call your next witness.
No further witnesses. Your Honor.
Let's call witnesses.
No, Your Honor.
We can proceed to argument.
Thank you, Your Honor. Sorry, I'm just trying to bring something up. Your Honor, the people would ask that this be bound over as charged. That being count one, fleeing and looting in the third degree. We just ask that the court take judicial notice that the location here at North Martin Luther King and West Oakland, the speed limit is 35 miles per hour. And the count one, fleeing and looting third degree, the people have the burden of showing that first, that a police officer was in uniform and or was performing his or her duties, and that any vehicle driven by the officer was identified as a law enforcement vehicle. The testimony presented that the officer was in a Lansing Police Department once patrol vehicle. Second, that the defendant was driving, excuse me.
Okay, thank you.
Second, that the defendant was driving a motor vehicle. That was established, that we could see in the evidence in the dash cam video and the body cam video, as well as the testimony from the officer identifying the defendant as the person that she had interacted with that night. The defendant was driving a great Porsche. And third, that the officer ordered the defendant to stop. In this case, the traffic stop was conducted because of a report that the officers had taken upon noticing that a license plate was expired and discovering that the plate was also on the wrong vehicle. Fourth, that the defendant knew of the order. We saw in the video when the traffic lights came on, when the traffic stop was initiated and the overhead lights of the squad car came on, there were no other traffic on the road between the officer and the defendant. The defendant continued on for some ways without slowing down, turning off the road and then ultimately into a driveway. The conditions on the road at the time and at the time of night, given the distance between the squad car and the defendant had reason to know that he was being subjected to a traffic stop by the officer. And then fifth, that the defendant refused to obey the order by trying to flee or avoid being caught. The dash cam video showed that the defendant continued on for a while, turned off the road and then into a driveway. And then even after stopping the vehicle, got out of the vehicle and then tried to get away from the officers. So therefore, based on the testimony and the evidence, the people would be asking that the defendant be bound over on count 1, fleeing and eluding in the 3rd degree. People would also ask that count 2 be bound over as charged. This is resisting and obstructing a police officer. The people have the burden of showing probable cause. First, that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered. In this case, this was Officer Catherine Rogers, but present at the time was also Officer Jake Ellis, who were police officers with the Lansing Police Department. Second, that the defendant knew or had reason to know that these officers were officers performing their duties at the time. In this case, the defendant was followed by the officers in their marked patrol vehicle with the overhead lights on, clearly indicating that they were police officers. And then further, the testimony and the evidence also showed that when the defendant got out of the vehicle, he looked directly at what we could tell from the dash cam footage was Officer Jake Ellis, who was dressed in his Lansing Police Department uniform. Third, that the officer gave the defendant a lawful command, was making a lawful arrest, or was otherwise performing a lawful act. In this case, the officer was in the process of conducting a traffic stop for the defendant, again, based on the testimony relating from what was discovered to be an improper license plate. The officer and the defendant, from what we could see in the evidence, once again, looked directly at each other. The defendant was able to recognize the officer in uniform, who was in the process of effecting a traffic stop. The defendant started to walk away and move away from the officers. The officer did not give a command to stop, but things happened very quickly in those moments. The officer did say "don't" twice, that we could see and hear in the dash cam video and the body cam video, and the defendant moved away from the officer in spite of those commands. I think those are the 3 elements for count 2. Based on the testimony and the evidence presented, Your Honor, we would ask that this case be bound over as charged on counts 1, 2, and the habitual offender 4th notice. Thank you.
Thank you.
Thank you, Your Honor. The elements for both of these crimes are very much similar. Was there an officer in fully marked uniform or patrol car? I don't think that's in dispute. Did they have, were they engaging in their lawful duties? I believe that's not in dispute. In fact, the element I do want to focus on each of these offenses is the intent. They have to, yes, the burden is on the prosecutor. They have to show just probable cause, but they have to show probable cause for every element. And there is in each one of these offenses an intent element. It has to, they have to also show probable cause that Mr. Perez intended to, 1, flee the police, and 2, fail to comply with a lawful order. All right, so in the fleeing and eluding, the evidence today was solely from Officer Rogers. We did not hear from Officer Ellis. So Officer Rogers testified that Mr. Perez did not slow down, but he also did not speed up. He, after a few blocks on Oakland Avenue, he turned onto Kaywood, and then he pulled into a driveway. Now, Officer Ellis couldn't testify that she knew that this was his driveway, but we could hear from the evidence that Mr. Perez emphatically telling Officer Ellis, "This is my home, I'm just going home." So the argument, I guess, based on what we have so far, is that Mr. Perez was intending to flee or run away from the officers. That was his intention, was to elude them. But we can see from the evidence, there is no evidence that he was actually eluding the police. He himself said, I was going home. His home, when the lights initiated, he simply had to go a few more blocks and turn left onto his street and pull into his driveway before he was home. So I don't believe that there's any evidence that shows today in regards to fleeing, eluding the third offense that Mr. Perez was trying to flee and or elude the police. And then they'll have to prove that at trial beyond reasonable doubt. Today, it's just probable cause. And I don't even think they met that burden. In regards to the resisting and obstruction, we heard from Officer Rogers that she believes that there was some verbal command that Officer Ellis gave to Mr. Perez that evening. She doesn't recall what it is. I think that's important, Your Honor. If we need to figure out whether there's probable cause, Mr. Perez who knowingly failed to violate a verbal command, we need to know what that verbal command was. The evidence that we've shown shows we have video that shows very clearly that Ellis was engaging Perez once they were outside of their vehicles, and that you can see Mr. Perez backing up, and then what I believe in the video you see is Officer Ellis running for Mr. Perez, and then Mr. Perez, whether he was backing up, running away, you don't really see too much of that, except for you do see Ellis running towards him and tackling him in the front yard. So again, Your Honor, going back to the elements, they have to show some evidence that he intended to resist the officers, he intended to flee the officers. I don't believe that they presented any of that. I believe whatever you see here, it happened all so fast. By the video itself, Mr. Perez saying, I was just trying to go home. He's a man, it's in the middle of the night. He, on a one-way street on Oakland, where there's nowhere to pull off to, and you just have to stop right in the middle of the lane. We would like the court to consider that whether or not there is sufficient evidence to show that Mr. Perez intended to flee or resist the officers. And if not, we ask that these matters be dismissed. Thank you.
Ms. Nickel, do you mind playing, I don't know, was it you who played the video?
Yeah, which one, Your Honor? I did, I played both. Which one
It must be People's One.
Yes, Your Honor.
I believe it's the one that shows when they activated, yeah, the dash cam.
Yes, Your Honor. I'll bring that up. I think I need to log out of Zoom and get that.
Oh.
Okay. Oops. Okay, here we go. Right here, Your Honor?
Yes, please.
They're opening.
signed.
35, okay. 32, we are really slow to stop. We're going about 15 miles an hour south on Kaywood right now. Copy, slow to stop. Any units closer than 33?
Simmons just wants an ambulance.
Okay, you can stop. Oh, today was a date scheduled for preliminary examination. The burden is on the prosecution to establish that there's more than mere suspicion that the felonies charged in this complaint were committed, and more than mere suspicion to charge you, Mr. Perez, as the person who committed these felonies. So this is not a trial. They don't need to prove each element beyond a reasonable doubt. The court will be the sole determiner of any credibility issues, and I'll also weigh the likelihood of the prosecution's success at trial. And so we have here count one, police officer fleeing, eluding in the third degree under the penal code, which would require that the prosecution prove first that the police officer was in uniform and was performing lawful duties, and that any vehicle driven by the officer was identified as a law enforcement vehicle. Second, that the defendant was driving a motor vehicle. Third, that the police officer or the officer ordered the defendant to stop his vehicle. Fourth, that the defendant knew of the order. Fifth, that the defendant refused to obey the order by trying to flee or avoid being caught. And then it says choose one or both of the following. Sixth, that the violation resulted in a collision or accident, which is not the case here, or some portion of the violation took place in an area where the speed limit was 35 miles per hour or less. And I think Mr. Nagel took put on the record for the court to take judicial notice of the speed limit. Also, when we played the dash cam, I did notice, it's a residential area. And I noticed just prior to turning left on, I believe it's the Kaywood Street address or street, there was a noted school zone on the pavement of the roadway. The officer today, Catherine Rogers, who is a relatively new officer, testified that on or about January 31st, 2025, that she, along with Officer Ellis, Jake Ellis, would effectuated a traffic stop on a vehicle for improper plate, that the vehicle continued or failed to stop after the Officer Ellis had initiated his lights. Vehicle continued and going in a speed limit, in an area where the speed limit was, she believed, of 35 miles per hour, and that the vehicle turned off Oakland onto Kaywood. That the entire time, from the time or the point that the vehicle, that the officers are in, activated their lights, to the time that the defendant got out of the vehicle, or the person that she identified in the court as the defendant got out of the vehicle, that they were 1 or 2 car lengths apart at most, that there was no traffic in between them. That at the time that the vehicle was stopped, that it was stopped at the area at 721 Kaywood, and that the defendant drove into the driveway of that residence. The defendant got out of the vehicle, turned toward the house, ignoring any commands, and attempted to go into the home. And he was at some point taken to the ground, or maybe fell to the ground and was taken into custody. The court saw the video, both dash cam and even the officer's video evidence. And the first element, which is that the police officer was in uniform and was performing their lawful duties, and that the vehicle driven by the officers, that's satisfied by the testimony of the officer. They were in fully marked uniforms, wearing their police uniforms in a fully marked police vehicle, and that they activated their lights. They activated those lights quite far from where the defendant even pulled into the driveway. It's not clear whether or not that's the actual address of the defendant, even though the defendant saying he's just going home. I don't even believe that there's a Kaywood address is what we have on record, or that the defendant gave a Kaywood address at the time that he was arraigned as the place where he lives. Nonetheless, second, the defendant must have been driving a vehicle, which we saw evident in the testimony and in the video. The defendant, or the person identified in this court today as a defendant, was driving a vehicle. The question or concern I believe that the defense's argument is whether or not there was an order for the defendant to stop the vehicle. I think when we're dealing with a fleeing and eluding, the order obviously is that the lights and the sirens are going out. It doesn't necessarily require the officers to yell out or to put on a bullhorn for you to stop your vehicle. It's commonly known in American society, I can't speak to other countries, but if an officer pulls behind you and they activate their lights, even if you didn't hear a siren, the activation of the lights behind you is as a signal to you that you are ordered to stop your vehicle. Fourth, that the defendant knew of the order. Absolutely unequivocal based on the information there that I believe the defendant knew or had reason to know that there was law enforcement behind him flashing their lights and I heard sirens. Fifth, that the defendant refused to obey the order by trying to flee or elude. The defendant is, or the defense is arguing that the defendant didn't try to elude, that he was just trying to go home. I don't dispute that he was trying to go home or go wherever he was going. That's really not relevant where you were trying to go. If the officer stopped you, you were to stop, and that didn't take place in the video. The other concern that the court has is the argument that the lights of the officers were activated on MLK and that there was likely no safe place, I suppose, to pull over, which is why I had the prosecution replay the video, because I watched as the lights were activated while on MLK. We're passing the church, we're going down Oakland Ave, and we passed Sparrow Hospital and other businesses to the left where the defendant or the driver of the vehicle could have safely pulled into a parking lot of a business for the purposes of figuring out why he was being pulled over, which it appeared was for a traffic violation. And so, but that didn't happen. The signals were completely ignored. Well over a mile, the vehicle traveled, and even after it turned on Kaywood, I noted that there were areas on Kaywood. If maybe you didn't want to stop at the business or you didn't want to stop on Oakland because it's a busy road. Well, when you turned on Kaywood, I see that there was areas where the driver could have pulled over safely to the left side of the street on Kaywood off the main road so that the officer could effectuate their traffic stop. But that's not what happened. Even after the vehicle stopped at the address at 721 Kaywood, if that's the address, the additional concern is that the driver did not pull over for the purposes of handling the traffic stop order. The driver pulled over, jumps out the vehicle and tries to go in the house, and the officer's got to run up behind them, and telling them that you just want to go home and that you're not doing anything is not the appropriate way to handle a traffic stop. And I have reason to believe, based on how this is charged, that the defendant should be familiar with how to do a traffic stop, because this is charged as a habitual offender, fourth offense notice, and one of the charges being that he was convicted of the offense of police officer fleeing. So I can't even reasonably believe that this is the first time that maybe this person has been pulled over and doesn't understand how you effectuate a traffic stop. So based on the testimony and evidence presented as to count one, there is sufficient probable cause as to count one that will be bound over to the circuit court. The count two police officer fleeing and eluding, I do agree. I'm sorry, assaulting, resisting, I do agree. The facts are and the elements are very similar. And the people would need to prove at trial that the defendant either assaulted, battered, wounded, resisted, obstructed, endangered, or opposed, in this case, Officer Jake Ellis, who was the officer or an authorized person, and that he failed to comply with a lawful command, or the defendant must have actually resisted by what he did, said, or said, but physical violence is not necessary. Second, that the defendant knew or had reason to know that Officer Ellis was a police officer performing his duties at the time. Third, that the defendant gave, or I'm sorry, that the officer gave the defendant a lawful command, was making a lawful arrest, or was otherwise performing a lawful act. In this particular case, the officer was in complete uniform and in a fully marked vehicle, activated lights and a siren indicating that the defendant was to stop. The defendant failed to stop, drove to wherever he was going or wherever he felt like stopping, pulled into a driveway, exited the vehicle, and attempted to rush inside of a home based on the evidence in the testimony, to which the officer I saw on the body cam exit the vehicle. I didn't hear any commands. However, I think under the circumstances, the officers, and it appears based on the age or the years in which Officer Rogers is here, that she's obviously being trained, and that Jake Ellis is the officer that's training her, and maybe under the circumstances failed to, or maybe the body cam didn't pick up. I know there's a delay before the audio picks up, so I don't know if it's just something that was missed, but I heard no command stop or any of that nature. But based on what I saw, it was reasonable for me to believe that the defendant knew that the officers were there for him and that he was supposed to stop, and his response was, I just want to go home, I'm not doing anything. That's not what your options are when you are stopped for a traffic stop. The court satisfied based on the testimony that there was reason for the defendant to know that the officers were performing a duty and that they were making a traffic stop. I also believe that the testimony and evidence support by a probable cause standard that the officer gave a lawful command or was making or performing a lawful act. Although there was no statement to stop, the officers had been following him with a siren and lights flash. He pulls into a driveway and not really all the way into the driveway, and immediately exits the vehicle and tries to hop out. And officers run behind him, and he slips, and it looks like he slips at least, and they fall on top of him. He's taken into custody. The court satisfied as to the elements of count 2 that will be bound over to the circuit court. Both counts are bound over for a bind over date. The 5th of March. Today's the March 5th, and that's not the date, sir, that you need to appear in the circuit court. That's a date the circuit court will get the file from the district court. Your next court date will be a pre-trial in the circuit court, okay? Do you have any questions for the court? Bond was set at 3,010%, and that will continue. Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor.
You're all set.